All right. Time is 10:27. The date is Tuesday. Well, the day is Tuesday. The date is January 20th, 2026. We are gathered again in the matter of the people. I was going to say the people of the state of Michigan versus because of the 234 trials that I had as a circuit judge, about two-thirds of them were criminal in nature. And of the 10,000 cases I had, 6,000 were criminal in nature. So the caption was always started with people of the state of Michigan versus. So we're not in a criminal case. I'm not a circuit judge. I may have the privilege of being court of claims judge. And this is the matter of the Kriegers et al. Versus the Department of Environment, Great Lakes and Energy et al. It is our case 20-0094 et al. There are thousands of plaintiffs. There are, I think, two defendants. So at least it would be easier to say all the defendants' names. At any rate, I hope everyone is well and had a pleasant weekend. We did have I had a phone conference with some of the lawyers yesterday. And as I said in the most recent scheduling order, that when those things took place, I would summarize them on the record the next time we were together. Would note it's now 10:30. We had originally planned to be together at 8:30 this morning. The reason we didn't start at 8:30 is because there was a request by one of the parties to push the start time to 10:30 for a lot of good reasons. Both sides had well-stated positions of why we should start at 8:30 or why we should start at 10:30. I did have a phone message from Mr. Dubin that arrived on my cell phone at 2:39 p.m. yesterday. Unfortunately, I had the ringer turned off. I was with my family and doing some family things. When I saw the message, I immediately called, and Mr. Dubin was kind enough to indicate that in his voicemail that he was calling and that I think Mr. Gamble was on the line when he called. I'm not 100% sure the first time. I think he was. I know Ms. Ullman Road and Mr. Wan were with him. And so he said, Judge, if you could call me back, I'll get Mr. Gamble on the call and I'll have Ms. Ullman Road and Mr. Wan with me. So as soon as I got the message, I called right away. I asked if it was okay with my family. I called and they said fine. I did. Anyway, we had a 6-minute phone call. Went back and forth on whether to seek to start at 8:30 today. And well, one of the sides wanted to, the other side thought it'd be more prudent to start at 10:30. And I said, I decided then, and it doesn't, frankly, in my estimation, matter who wanted to start at 8:30 and who wanted to start at 10:30. But what I said was yesterday, we had a 104 car collision 23 miles from where we're sitting right now. As a result of the weather and the icing on the highways. Of those 104 vehicles, 17 were semis. When we were having our conversation, the four lawyers and I, the cars were still not cleared. And also yesterday, on the Dr. Martin Luther King holiday, there was a section of Interstate 96 had to be closed between Lansing and Howell for a period of time. And my recollection is there was a section of US 131 that also had to be closed. And I reached the decision almost immediately I made the decision almost immediately that given the extreme weather that we were experiencing yesterday, we have endorsed lawyers from Chicago in this case. We have endorsed lawyers from the Detroit area in this case. We have witnesses from throughout the United States that it was just not prudent to try to proceed at 8:30. So I made a decision that we would start today at 10:30. So that's why we're here later as opposed to 8:30. I think the court's IT department, who my understanding is, posted something that told people that we were starting at 10:30. So I appreciate that. But if there's anything else that anyone wants to memorialize from yesterday's discussions, I'd be happy to let the parties amplify the record. Mr. Dubin is not in the courtroom right now. Mr. Juan stands.
Entirely accurate based on my participation.
Okay. All right. Anything else for the plaintiffs before we proceed to our next witness?
Just kind of a housekeeping measure. The court had reached out to the parties and the idea of when witness submissions as opposed to oral argument.
Oh, right. Yeah.
Both sides are in agreement that that's the best way to proceed.
Okay.
The issue for us is timing.
Mhm.
What I would suggest to the court, and defense counsel can do this as well. We would like 3 weeks from the date we get the transcript. Ours.
Wow.
I think the state would like, you want to basically the same amount of time we have, and then a week for a rebuttal. As we do a closing argument, a brief rebuttal. That's what I would throw out there as a proposal.
Okay. We'll address that in a second. And you might have seen me grimace a little bit on the 3 weeks, and I'll tell you why in a second. Mr. Gamble, as far as the memorialization of the record for anything from yesterday leading to us having a 2-hour delay today, anything you want to add?
No.
Okay. Okay. So follow up on Mr. Wan's comments.
So, yes, defendants are agreement are in agreement.
Do you prefer a written submission?
Yes.
Okay. All right. So that's a starting point that we have agreement. So I remember when I was a baby judge, Judge Quiz used to say, now, Jim, I know you think you know all that in a bag of chips, but if the lawyers agree on something, you usually should probably let them do it. I said, okay, so I don't want to always defer to lawyers, but okay. So we understand that you both think that's good. What about the schedule timing wise?
That's something we can talk about a little bit more. Getting significant to the court. We think that the record here is substantial enough that it'll take a fair amount of time. To go through it.
Yeah.
And so I think giving it a cushion and time would be important.
Right. 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 Okay. I'm not going to make a decision right now to say, okay, you're going to get, 2 weeks and not anymore, or 3 weeks and not a minute less or whatever. Here, I'll just be candid with the lawyers and the parties that are watching. When we set this trial in July, when the court's schedule continued to move forward, the way that our court works, the Court of Appeals works, is each judicial officer, and there are 25 of us, by October 1st of every year, we have to provide to the clerk of court our scheduling, our clerk, and they're in charge of scheduling, setting up all the panels that address the 5,000 cases that the Court of Appeals of the state of Michigan addresses each year. What month it is you want as your vacation month, and we also have both a case call docket and a motion docket. And so I said, here's what I want for my vacation month in this calendar year 2026. And additionally, court staff, I am asking specifically that I have a January case call because I know I can get ready for it, but that I not have a February or a March case call because I'm going to be dealing with the Edenville Dam case and the RJ Reynolds versus the state of Michigan case in December and January, which makes it all sound very reasonable to have a 3-week delay. But that was based on what happens is we start working as Court of Appeals judges on, for example, if I'm in the April docket, which I am, my duties begin March 1st. So I am spending the entire month of March preparing for my April, or much of it preparing for my April case call. I've assumed I would be working on these cases certainly throughout all of February. This case, the other case is settled, so I don't have to work on that. But having a 3-week period after the completion of proofs is going to be hard. So it may be a 2-week. I understand, and maybe I understand, and I'm not making any decision right now. The plaintiffs have been seeking a resolution of these claims since before June 1st, 2020. That was the peak of COVID. I mean, we all remember, and there's been much that has happened as a society, as a state, as a nation since then. So I don't want to be selfish about this, but I also want to recognize I have other responsibilities. So we'll talk about it off the record. The lawyers and I'll meet in the caucus room at some point, maybe this week. We can figure out 20 minutes where we can talk together about schedule.
But I point out one thing to the board that is a good thing that was not quite expected. And based on the number of witnesses that both sides named, the court thought it was going to be about 6 weeks.
No,
I think it'll be done next Tuesday or Wednesday. And so.
okay. Well, the plaintiffs or the whole?
Oh, we received.
Do you think that's true?
Order of witnesses are.
Yeah.
Okay.
I think the plaintiffs are anticipating that tomorrow.
That's
Right. I think plaintiffs are done tomorrow. I kind of figured, okay, well, that's a horse of a different color.
Good
But
thing, Judge.
no, I completely agree. And I talked about it yesterday in our phone call. I said, listen, if we still had 800 witnesses endorsed by both sides, we weren't going to be taking 2-hour, adjournments. But no, that's good to know. So I appreciate that. And that will certainly, it's never a good business practice to punish litigants for being more efficient. So it's not good for the system. So anyway, yeah. I think we're going to Mr. Sturdivant next and continued cross. Is that right? Okay. Most importantly, Ms. Heacock, are you ready? I know, I got the look. Sorry. Elizabeth, are you ready? Dan, you ready?
Yeah.
Okay. All right. There he is. Good morning, Mr. Sturdivant. Uh-oh. You're on mute.
There we go.
Oh, good. It's like, oh my gosh. Oh, and by the way, we do have a three-peat of Big Ten football squads claiming the national championship. So anyway. All right. Mr. Gamble, I'm ready.
Thank you, Your Honor.
Thank you.
So, Mr. Sturdivant, because of the layout of the courtroom, in order to see you, I have to actually face away from you. So, unfortunately, I believe you're looking at the back of my head. Is that right, Mr. Sturdivant?
You're pretty tiny right now.
Yes.
Or you, actually. Whenever this happens, I always I live my life through vignettes of films, and I always think of Zoolander. What is this? A school for ants? So,
That's funny.
right.
Mr. Sturdivant, if you're unable to hear me or if the connection gets interrupted, please, or there's static or something, please let us know right away, and so that we can repeat the question. Do you understand? Okay, Mr. Sturdivant, can you hear me?
Very well.
And Mr. Sturdivant, are you consulting notes or anything like that in front of you there?
No.
Okay. Let's pick up from where we were discussing last week, a statement from your declaration in which you had said that Eagle disregarded explicit warnings about embankment stability. Do you remember us talking about that issue?
Yes, I do.
And we looked at the 1994 CSIR. We looked at the 1998 FERC license. We looked at the 2000 CSIR, the 2015 CSIR. We looked at the 2017 compliance order from FERC. Do you remember us going through some of those documents last time we were talking?
Yes, I do.
And those engineers, they recognized the lack of spillway capacity at the Edenville Dam, didn't they?
They did.
And none of them warned that the normal operating level of Wixom Lake was dangerous, did they?
I would respectfully disagree. Just by identifying the fact the spillway doesn't meet capacity means it's not capable of holding a normal water level safely.
None of those engineers advised that the dam owner should lower the level of Wixom Lake to mitigate the risk of the lack of spillway capacity, did they?
No,
So, in fact, in 1998, FERC in its license.
Can I just interrupt? The question was, none of those something warned the something, and the answer was no. And I know what that means, but it is, as the Sisters of Mercy that taught me in grade school, it was a double negative. So if we could just confirm that whatever it is with Mr. Sturtevant that you want to confirm, so there's no confusion on the record, I would be very appreciative.
Of course.
Thank you.
Mr. Sturtevant, did any of the engineers in those reports that we just mentioned advise the dam owner to lower Wixom Lake as a risk mitigation measure because of the lack of spillway capacity?
not in those exact words. No,
Did any of them advise lowering Wixom Lake at all?
I believe that there was some correspondence, at least, that went back and forth that talked about lowering the water level as a remediation technique.
In which report are you referring to?
I believe I'm referring to emails.
Is there an engineering report that contained that language?
Not to my recollection, no.
Starting in 1998, when FERC issued its order, or excuse me, its license for the Edenville Dam, that license actually required Boyce Hydro to maintain the normal summer level of Wixom Lake, didn't it?
It did.
And in 2017, in FERC's remediation order, FERC acknowledged, they identified several risk mitigation measures as a way to add hydraulic capacity to the dam because of its lack of spillway capacity, didn't they?
They did.
But lowering Wixom Lake, it was not one of those measures, was it?
Not directly, no.
And FERC, they could have ordered Boyce Hydro to lower Wixom Lake, couldn't they?
Yes,
But as they explained to Congress after the dam failure, their staff considered and they rejected the idea of ordering Wixom Lake, didn't they? To be lowered, didn't they?
yes.
Amy, could you please bring up D106, the IFT report? Mr. Sturtevant, are you able to see this IFT report? Okay.
Yes, I am.
Amy, could you go to page 352? Could you magnify the big fully highlighted paragraph there? On page 352 of the IFT report, Mr. Sturtevant, are you able to see these words okay?
Yes, I am.
The U.S. Army Corps of Engineers, do you see in the middle of this paragraph? It said the U.S. Army Corps of Engineers investigated the flood hazard reduction potential of Wolverine's projects and found it to be negligible. Do you see that?
I do.
And then two sentences later, it says, the flood control benefits of the late winter drawdown are negligible in true flood situations. Do you see that?
Yes,
And then the final sentence that's highlighted in blue, it says that these conclusions, these historic conclusions from the U.S. Army Corps of Engineers, they were confirmed by the IFD's hydrologic and hydraulic analyses, which showed that pre-lowering of Wixom Lake before the May 17th through 19th event would have had very little effect on the ultimate lake level during the storm. Do you see that?
I do.
And Amy, if we could go down to the next page. Could you magnify the chart, the graph? Have you reviewed this chart previously,
have.
Mr. Sturdivant?
Yes,
It shows that the highest that Wixom Lake ever got prior to the flood that caused the dam failure was much lower than the actual dam failure height, right? I mean, do you see the end of the graph there?
yeah, it was somewhat lower, approximately 3 feet.
It had never gotten as close to the level that it reached in May 2020, had it?
No,
It was truly unprecedented, that level in May 2020, right?
yes, but not unpredictable.
Amy, could we bring up D101?
Oops. I have an automatic light, sorry.
Could you magnify the top, including the first paragraph? Thank you. Mr. Sturdivant, do you see that this is an email from Lee Mueller on February 17th, 2022 to Irfan Alvi?
Yes,
And you recognize Irfan Alvi's name as a member of the independent forensic team, right?
yes.
Could you please read the highlighted sentence in the email for us?
The only reference to the advisability of lowering the Edenville Reservoir impoundment to run of river level for purposes of mitigating or attenuating potential flood events that I can recall is my correspondence to FERC in 2013, wherein I stated that pre-lowering of the Edenville Dam Reservoir was a prudent option for at least providing a degree of attenuation of the PMF flood event.
Is this the email you referred to earlier in your testimony today?
It is one of them, yes.
And Mr. Mueller, he says that the only reference to advising, to the advisability of lowering the reservoir to mitigate spring floods was in his correspondence back in 2013, right?
I can't accurately, I can't
Well, that's what he
buy
says.
that statement. That's what he says, but I can't verify it.
Because you didn't speak to Mr. Mueller at all, did you?
That's correct.
Okay, can you bring up D8, please? So if you can see at the top of this, this is the May 2013 letter. It's from Boyce Hydro to the Federal Energy Regulatory Commission. Do you see that?
Yep, the Secretary Bowes.
Could you magnify that last paragraph? Thank you, Amy. In this letter, Mr. Mueller remarks about a conference call, and he said that FERC's director of dam safety asked Boyce to develop a plan for interim mitigation of the potential PMF event, given the fact that the Edenville Dam does not have the requisite capacity to safely pass the PMF. Do you see that?
Yes,
And then he said, it was suggested that the only near-term option for providing any meaningful form of mitigation would be to lower the impoundment, Wixom Lake, approximately 8 feet to the level of the spillway crests, thereby providing a safety buffer for flood water discharge. Do you see that?
exactly. Yes.
Okay, so let's pull up D9. So that was a May 2013 email. So do you see that this is a letter from the Federal Energy Regulatory Commission back to Mr. Mueller? It's dated June 13th, 2013. Do you see that at the top?
Yes.
Can you magnify that paragraph, Amy? Thank you. So FERC writes back and says, given this current scope of work required to remediate the projects and construction hurdles outlined in your May 20th, 2013 letter, we request that the Board of Consultants be reconvened to determine if other engineering alternatives are available, which could provide for the long-term safety of this project. Do you see that?
Yep. Common practice.
So a Board of Consultants, are those a group of independent engineers that the dam owner hires to review a proposal?
Yes.
That's, I think you just said that's standard practice with FERC regulated dams, right?
That's what I've seen. Yes.
Amy, could you go to the next page, please? And FERC lays out, oh, that's not the page I thought it was. It's fine. And then why don't you bring up D30? Oh, wait, there it is. Thank you. And FERC outlines the topics that they want the Board of Consultants to consider with the dam owner. And one of those is inflow predictions and the effects of a pre-drawdown ahead of flood events. Do you see that?
I do.
So in 2013, FERC asked the dam owner to consult with a Board of Consultants, independent engineers, to consider the effects of a pre-drawdown ahead of flood events, right?
Yes.
Amy, could you pull up D13?
D13.
D13.
Thank you.
And this is
Interrupt just real quick.
of course.
I just want to indicate on the record, about 10 minutes ago, I asked my law clerk to get me a protein bar. And the reason I did is I'm somewhat hypoglycemic. I know that I am. And I have in the refrigerator immediately adjacent to the courtroom, have some stuff stashed there. And instead of taking a recess, I just decided that was what I wanted to do. I wanted to say that and put it on the record so that if any of the lawyers or anyone watching says, I think the judge is eating during the trial, how rude is that? And the fact of the matter is, I am consuming calories during the trial, and it's for the purpose of trying to be as efficient and respectful of the lawyers and the witnesses' time that I didn't take a recess, but I knew that I needed to get something in me. And if anybody happened to see it, that's why I'm doing it. So anyway, if anybody's any objection, please feel free to say it now. Oh, no one indicating. All right, let's continue.
Thank you, Your Honor.
You're welcome.
So, Mr. Sturtevant, Defendants Exhibit 13, do you see that this is a November 29th, 2013 message from Frank Christie to the Federal Energy Regulatory Commission?
Yes.
Frank Christie is a professional engineer, isn't he?
That's what I see. Yes.
And do you recognize him as Boyce Hydro's dam safety engineer?
I have seen that reference. Yes.
And Amy, if you could go down to the next page. This is some additional evaluations about PMF alterations prepared by Christie Engineering. Do you see that?
Yes.
And then let's go to the next page. Boyce Hydro's dam safety engineer, he reports back to the Federal Energy Regulatory Commission about this pre-lowering concept. Can you highlight that for us, Amy? Thank you. Mr. Sturtevant, could you read that paragraph for us, please, into the record?
We have further evaluated the pre-lowering concept presented in the September 2013 submittal and have determined the only benefit would be a delay of 6 hours in the arrival of the flood peak. The peak flood elevation and flow would not be changed. Therefore, based on the magnitude of the PMF flow and the early weather warnings we get 4 to 6 days, we do not see any significant benefit from attempting to lower the reservoirs in advance of a possible PMF condition. I would expect that. They're
Thank you,
looking
Mr.
at
Sturtevant.
the PMF. Yes.
Thank you, Mr. Sturtevant. In this 2013 analysis, Boyce Hydro's dam safety engineer ultimately reported to FERC that Boyce Hydro did not see any significant benefit from attempting to lower the reservoirs in advance of a possible PMF condition, right? Isn't that what he said?
Yes, addressing the PMF.
Amy, could you bring up D15, D15? Defendants 15. And you see, Mr. Sturtevant, this is a letter back to Boyce Hydro from the Federal Energy Regulatory Commission dated February 11th, 2014. Do you see that?
I do.
In the top salutation and first paragraph, FERC explains that they've completed the review of Boyce Hydro's submittals regarding various temporary and permanent risk reduction measures for your Edenville Hydro project. Do you see that?
Yes.
Amy, could you go to the next page, please? One of those risk reduction measures that was studied was pre-lowering of the reservoir. Do you see that?
Yes.
And ultimately, FERC said that Boyce Hydro should confirm if pre-lowering of the reservoir to accommodate extreme rainfall events is being considered. Then it notes that Mr. Frank Christie indicated during a phone conversation on January 13th, 2014, that there are limited benefits to pre-lowering the reservoir as a risk reduction measure. Do you see that?
I do.
Are you aware of any point that FERC directed Boyce Hydro to pre-lower the reservoir?
No.
It simply says that Boyce Hydro, if you're thinking about doing this, let us know, basically. I mean, is that essentially what they say?
Yes, that they're considering it. Yes.
And they remarked that Mr. Christie, Boyce Hydro's dam safety engineer, indicated that there are limited benefits to pre-lowering the reservoir as a risk reduction measure, right?
Yes.
And ultimately, and we can bring up the letter to Congress if we need to, but FERC confirmed that their staff did not considered but decided not to order Boyce Hydro to pre-lower Wixom Lake, right?
That's correct.
Amy, you can take that down. Thank you. I believe you testified last week that a lack of spillway capacity was a warning about embankment stability because the previous stability analyses done at the Edenville Dam had not analyzed the embankments of the dam at full pool levels. Is that correct?
Not entirely. The studies that appear and that are using current technologies investigated the embankments that had already gone under remediation, had filter blankets installed or they're called filter diaphragms on the downstream side of the embankments. And that's where the stability analysis occurred, not on the left embankment that failed.
Okay, but the testimony from last week was about whether the Department of Environment, Great Lakes and Energy had ignored, quote, explicit warnings about embankment stability, unquote. That's from your declaration. Do you remember us talking about that issue?
I do.
The 2015 CSIR does not include any explicit warnings about embankment stability, does it?
No, they discounted it based on that stability analysis that did not include the part of the dam that failed. I think that was an error.
You're not aware that of any circumstance where the Federal Energy Regulatory Commission identified that error for Boyce Hydro and asked them to correct it, did they?
They did not.
The CSIR, that's done under the direction of FERC regulations, isn't it?
It is.
It's typical for FERC to review those CSIR reports and ask dam owners to provide additional analyses if they're warranted, right?
Yes.
And FERC did not ever do that for the 2015 CSIR, did it?
Not that I saw, no.
Amy, could you bring up P216? I think we've seen this report about 100 times, Mr. Sturdivant. But you
At least.
recognize
Oh, yes,
2015 CSIR?
I do.
Okay, Amy, could you go to page 12, please? So the engineer's reporting about his conclusions regarding the field inspection. And Amy, could you highlight that middle, or excuse me, magnify that middle highlight? In fact, the 2015 inspection, the engineer remarked that the project embankments appeared to be stable and well maintained with no obvious signs of unusual movement. There were no cracks, slumps, sloughs, depressions, or wet areas observed on the embankments. Do you see that?
I do.
Let's go to page 39, Amy. So you see that this is a report again about the field inspection that the engineer did at the top, Mr. Sturdivant.
Yes.
Okay, next page, Amy. Specific to the Edenville embankment, the engineer remarks that the left embankment was found to be in very good condition with healthy grass growth. Do you see that?
I do.
He doesn't identify anything in here about embankment stability, does he?
He does not.
He even says that the drainage ditch appeared to be functioning properly with the drain pipes freely discharging into the collector trench. Do you see that?
Yes.
And he ultimately ends with the drain appears to be functioning.
Yes.
Hold on, please.
It's loading. I think it's on fire.
What's it loading?
I don't know. I got an exception message and now it's like trying to catch up.
Okay,
I have to just break.
all right. Wait.
Okay, there were no slots. Okay, the last, do that, hold on. Almost there. have not been used by the computer guys.
Not cooperating?
Hold on,
No,
sorry, just a moment. I think I'm almost there. Okay, I'm currently back on. Thank you for
we good?
your
Of
patience.
course. You're good, Terry.
I'm good at this moment, thank you. I have no idea what I'm saying. Go ahead.
Thank you. So looking at plaintiff's exhibit 216, page 40, the engineer in his report noted in that second sentence, generally, there were no slumps, slides, cracks, or other unusual conditions noted, right?
That's correct.
Amy, can we go to page 68? And in this section of the report, the engineer reviews the stability and stress analysis of the project structures. Do you see that, Mr. Sturdivant?
I do.
And if we scroll down, he notes that the liquefaction analysis summary, and we discussed that the other day, which is that due to the combination of the soil properties and the low energy of a potential earthquake, he just didn't think liquefaction was an issue for this dam, right?
That is correct.
And then if we go down to page 69, could you magnify that bottom highlighted area? Thank you. Now, Mr. Sturdivant, if you look right in the middle of that large paragraph, it says that the report indicates, do you see that sentence I'm referring to?
Yes, I do.
The report indicates that the weighted filter toe drain provides adequate factors of safety for both the normal pool and the full pool potential slope failure scenarios for the dam. Do you see that?
I do.
So for this,
Hold on a second. What line of the highlighted section? And I apologize. Are you reading from?
right in the middle, if you see
Okay,
Amy's
I have it
arrow.
now. Thank
Yeah,
you.
there you go.
Let me just have a moment,
Of course.
please. Thank you.
So Mr. Sturdivant, for the stability analysis that were reviewed for this 2015 report, it determined that there were sufficient factors of safety for both the normal pool, but also the full pool condition, right?
Yes, in the weighted filter portion of the embankments.
And ultimately, that final paragraph at the bottom, it says that the drains act to intercept the phreatic line within the embankment and safely conveys the collected seepage to measurement weirs. Do you see that?
Exactly. There's a collection system in the bottom of those filters, in the bottom of the weighted filter. That's what the reference is, because they make no reference to any other part of the embankment.
Amy, could you go to page 26? So on page 26, this is section 3 of plaintiff's exhibit 216. It discusses the potential failure mode analysis that was done at the dam. Do you see that, Mr. Sturdivant?
I do.
And it refers to an original potential failure mode analysis in 2005, and then another potential failure mode analysis on August 6, 2015. Do you see that?
Correct. Yes.
And for the 2015 potential failure mode analysis, none of those people who were in attendance were state employees. Is that right? As far as you can tell?
As far as I can tell, that's correct.
Uh, three of them are engineers though, right?
Yes,
So there's Peter Chapman from FERC, there's Frank Christie, a general manager, and also Boyd's Hydro Dam safety engineer. But then there's Dee Perkypile, who's the one doing the 2015 CSIR, right?
yes,
And as part of a potential failure mode analysis, just to refresh everyone's memory, this is when it's like a tabletop exercise where they imagine different ways that the dam could fail, right?
yes,
And none of those imagined ways the dam could fail were static liquefaction, right?
no,
But they did review all information, all available information relating to the design, construction, operating performance, investigation, and safety evaluation of the Edenville Dam, right?
yes,
So at least according to this 2015 report, this group did review the available construction history of the dam, didn't they?
that's what it states here, and I do not know what the full extent of that was.
And as they identified risk reduction measures to control the risk of any of these imagined failure modes actually happening, none of those risk reduction measures were lowering Wixom Lake, were they?
No,
Amy, let's
Can
open.
I ask a question before you move on? I thought I heard you say, Mr. Gamble, in a preparatory phrase to one of the questions, you said two probable failure mode analysis is being reflected at page 26 or thereabouts of this exhibit. Did I hear you incorrectly, or
No, so Your
I see there are
Honor,
two dates or series of dates. So tell me what.
so if you look at the top, Your Honor, right under 3.1, it
Mhm.
refers to an original PFMA tabletop exercise. That was in 2005. So that
Oh
table.
gosh, I am so sorry. Okay.
Oh, that's
I
okay.
no, mine saw the June 13th through 15th, 2005, and I read it as 2015. That I understand now. I just partially, in addition to being hypoglycemic, I think I'm partially dyslexic. So anyway, so I understand now. Okay, 05 and 15. Thank you.
Yep. Amy, can you open up D106 to the IFT report?
It's clear as day. That's-
Let's go to page 127 of the IFT report. Amy, maybe you can go up one page so we can see the section that we are in. So if you look at the bottom, Mr. Sturdivant, this is section 7.1.5 of the IFT report, in which it discusses geotechnical investigation and analyses, right?
yes,
And a geotechnical investigation is when an embankment stability analysis would be performed. Is that correct?
that would be part of it, yes.
Okay. So Amy, could you go to the next page, please? And first we'll highlight, do you see at the bottom, it refers to a 1991 slope stability analysis?
Yes,
And we'll just look at first we'll go to the next page, but in 1991 for the downstream slope, it says the calculated factors of safety were 2.12 for the normal water level and 1.8 for a high water level at the embankment crest. You see that?
yes. Could
So-
I just see right above it, just to refresh my memory on something, please?
Yes, Amy, why don't you magnify that whole section?
What page?
This is page 127 of Defendant's Exhibit 106.
Okay, that's what I remembered was they
So-
used the phreatic surface based on the piezometers, or what they're calling here groundwater monitoring wells. But again, they couldn't have done that for the left embankment because there are no piezometers in that portion of the embankment.
And for this 1991 slope stability analysis, they did consider the stability of the downstream slope with the water all the way at the embankment crest, didn't they?
They did.
Amy, can you go to the next page just so we complete the sentence? So it in 1.76, and ultimately it said these factors of safety were judged to be satisfactory, right?
Correct.
May I have a moment, please?
Yes.
Thank you. Sturtevant, this is going to take me a minute to read a couple of things, so we haven't forgot about you. It's just me slow on the uptake.
I may take a moment to pour my coffee into a real cup then.
By all means, let's keep the caffeine flowing.
Thank you.
Thank you.
Mr. Sturtevant, let's go to page 131. And this refers to, if you see in the middle of the page, 2007 to 2009 embankment stability analysis. Do you see that, Mr. Sturtevant?
I do.
So Amy, could you please magnify the first two paragraphs under that section? So this will take a moment to go through. Mr. Sturtevant, this refers to an embankment stability analysis performed by Mill Road Engineering for Boise Hydro and reviewed by the Board of Consultants. Do you see that?
Yes.
And if we go down to that next paragraph, starting in the second sentence where it says stability analyses were completed. You see that?
Yes.
And it says, it goes on to say, the stability analysis were completed for normal water level and high water level at the embankment crest, right?
Yes.
And the resulting calculated factors of safety were 1.53 and 1.40 for normal and high water levels, respectively, for the case of the tow filter drain in place. Do you see that?
I do.
And then it says these factors of safety met FERC requirements. Do you see that?
I do.
And so let's go to the next two paragraphs, Amy, and magnify those, please. The one that says it should be noted that FERC, and the one after that. Yep, those ones. Thank you. So you had mentioned before that FERC oversees this type of stability analysis and will ask for engineers to provide it with additional details on occasion, right?
Yes,
And it looks like this is an example of that because the IFT reports that FERC reviewed the submissions of the stability analysis and apparently performed its own in-house stability analysis, concluding at one point that one of Mill Road Engineering's stability analysis was overly conservative and not consistent with the stability analysis previously performed by other consultants. Do you see that?
I do.
So what was FERC thought that the numbers were too low, basically, and that actually the embankments were more stable than Mill Road Engineering was thinking. Is that what you understand this statement to be?
I do. And again, this is the filtered portion of the embankment.
And so FERC staff asks Boise Hydro to go back to its engineer and do some more work, right?
Yes,
Then Amy, if you could then magnify the last two paragraphs, thank you. And then the Board of Consultants, those are independent engineers hired by the dam owner, right?
yes,
So the IFT reports that the Board of Consultants also reviewed the submissions of the stability analysis and performed its own stability analysis. Do you see that?
yes,
And they ultimately concluded, quote, even under the worst possible assumption of a fully saturated embankment with inoperable drains during the PMF or full pond, the factor of safety would be higher than 1.1, which in our opinion provides adequate safety for an extreme loading of a very short duration. Do you see that?
yes,
So at least according to this Board of Consultants, they didn't see, at least according to this summary by the IFT of this Board of Consultants review, the stability analysis, they didn't see any reason to do further studies of the dam's embankments, right?
no, and that should be a red flag. Why not? Because no one says why they ignored that left side of the dam.
So let's go down to page 153, Amy. And when you say a red flag, you meant that should have been a red flag for the Federal Energy Regulatory Commission?
And the state of Michigan.
So we're down to section 7.2.2.5, the effects of Eagle actions. Do you see that?
Yes,
Amy, could you highlight that or magnify that highlighted paragraph? Thank you. So let's start near the middle of that paragraph where it says, in the case of Edenville Dam. Do you see that, Amy?
I
Could
do.
you arrow on that? Yeah, right there. So it says, in the case of the Edenville Dam, the dam had already gone through a potential failure mode analysis, several geotechnical investigations, and 6 FERC Part 12D inspections and evaluations, the most recent being in 2015. The conclusions by the engineering consultants and FERC were that there were no significant embankment stability concerns which had not already been addressed by embankment overlays and drain modifications. Do you see that?
yes, and I don't.
And that's consistent with your review of the reports referred to by IFT, which is that none of these reports identified significant embankment stability concerns which had not already been addressed, right?
That is what it says.
Mr. Sturdivant, even if the dam could have passed the half PMF, if a storm came along that exceeded the half PMF, this dam still could have failed, right?
Yes,
So simply installing enough spillway capacity to satisfy the half PMF standard wouldn't have eliminated all risk of this dam failing, would it?
Not all the risk, no. Certainly the biggest piece.
And even if the Edenville Dam could pass half PMF, that would not have satisfied FERC safety concerns, would it?
No,
Amy, you can take that down. So I believe you were shown an email by Mr. Thompson from an engineer at Eagle in 2013 named Byron Lane. Does that ring a bell, Mr. Sturdivant?
yes,
And in that email, Mr. Lane said that as a preliminary matter, he didn't think that the Edenville Dam could meet half PMF back in 2013. Do you remember that correctly?
I do.
Okay. Are you aware that after that email was sent, the PMF for the Edenville Dam changed and actually went down?
It did go down temporarily until someone did a more accurate study, yes.
And Mr. Sturdivant, you had testified last time you were on the stand that the original gate heights for the Edenville Dam, their design height was to be opened to 10 feet. Am I remembering correctly your testimony?
There are a couple of conflicts. There's some that say 9.5 and some that say 10. The most current say 10.
Amy, could you bring D106 up again? The IFT report. Let's go to page 37. This is the section of IFT report down at the bottom, 2.5. This is page 37 of the exhibit, where the IFT discussed the spillway gate hoist. Do you see that, Mr. Sturdivant?
Yes,
And Amy, can you magnify those highlighted areas? Thank you. The IFT notes that the original spillway gate hoist systems were essentially the same at all four dams. Do you see that?
yes,
And then near the end, of that second paragraph, it says during the gate lifting process, the yoke of the chain lifting bridle catches on the underside of the hoist rail frame after about 6 to 7 feet of opening. Do you see that?
I do.
And then it says with this limitation, the gates could not be lifted clear of the spillway flow with the lake. Do you see that?
I do see that.
And then if we go to the next page to carry on with the sentence, it said the gates could not be lifted clear of the spillway flow with the lake surface a small amount, 1 to 2 feet higher than the normal lake elevations. Do you see that?
Yes,
And then hence flow through the gates during large flood releases would likely be orifice flow, right?
yes,
So this is referring to the way that the gates on all the dams were originally designed. They had this failure where they couldn't lift them more than 6 to 7 feet. Isn't that what this report's saying?
yes.
Amy, if we go to the next page after this one. Could you highlight, that area? Thank you. Or magnify that area. In that first highlighted section, it says efforts to increase the gate opening capability were not made until 2012. Do you see that?
Yes,
And Boyce Hydro reports about how there was a limitation on how high they could get the gates, and ultimately at the end, as of October 29, 2012, it says the gate opening height was corrected to 6 to 7 feet, right?
yes,
But Boyce Hydro, they put together a plan to try and fix this, didn't they?
yes. They built those A-frames.
The A-frames, right. So Amy, could you go to page 41? So with these A-frames, the gates could be lifted higher than they were originally able to, isn't that right?
Yes,
But then it was these A-frames that ultimately, because of the 2019 gate inspection, Boise Hydro was advised by Spicer Group not to use these anymore, right?
it was dangerous to use them during flood events.
Okay. And the last line there, hence after 2019, Edenville Dam was the only one of the 4 dams where the gates could not be opened fully without the A-frame system. Do you see that?
I do see that.
Um, and then Amy, let's finish this out by going to page 42, next page.
Can you hold on just a sec?
Yes, Your Honor.
Sorry. Okay. Thanks. Go ahead.
And down to page 42 of Exhibit 106, Mr. Sturtevant, ultimately the IFT summarizes that plans were being developed to modify the Edenville Dam gate hoist to allow for full opening, right?
Yes,
But at the time of the May 17 through May 19 flood, the engineering guidance was that use of these A-frames was unsafe. So during the May 2020 event, the gates were open to about 7 feet with limited use of the A-frames. Do you see that?
I do see that they could not operate them, or it was not safe to operate them during the flood.
So to summarize the IFT's summary of the gate history, they originally could only open 6 to 7 feet until Boise Hydro developed the A-frames in about 2012, 2013 to open them higher. But in 2019, they were advised that doing that would be unsafe. And so it went back to only being able to open them to about 7 feet, right?
I missed the 2019 warning. I got that it was a problem during the May 17th through 19th flood, that
The
it was safe to use the A-frames during a flood. That makes perfect sense because they're going to shake.
Right. And it was during the June 2019 gate inspection with Spicer Group and D Perky Pile in which they reached that conclusion that it would be unsafe to use them, right?
Yes, and again, I thought that reference was made during a flood, not under controlled conditions.
Okay. Changing topics back to part 307. Mr. Sturtevant, you may have testified about this last time. I apologize if I'm repeating myself, but you've never been involved in a state of Michigan part 307 lake level proceeding, have you?
No,
You testified last week that you never saw any indication that Luke Trumbull, Eagles Dam safety engineer, discussed the Edenville Dam's lack of spillway capacity with anyone who was, quote, involved with the Part 307 proceeding. Do you recall providing that testimony?
yes, I recall saying that he didn't provide any testimony at the hearing, or I did not say anything ahead to the circuit court.
And I believe you testified that Luke Trumbull did not provide that information to anyone, quote, involved with the Part 307 proceeding, right?
I can't really remember exactly what I said, but okay.
That's okay. Do you know the role that Spicer Group engineering firm played in the county's Part 307 proceeding in this case?
Believe that they were the engineer for Four Lakes Task Force.
They were actually appointed by the county as the engineer for the Part 307 proceeding, weren't they?
Oh, okay. Yes, thank you for clarifying.
Let's bring up D35, just to make the record really clear about what I am referring to. So do you recognize this as a resolution by Gladwin County? Looks like in October 2018. Are you able to see that, Mr. Sturdivant?
Yes,
Amy, if you go down to page 3. This is the resolution addressing the Part 307 proceeding and appointing the Four Lakes Task Force. And then, yeah, Amy, could you magnify that? So in this resolution, the county resolved that Spicer Group is appointed as the engineer for the lake level project. Do you see that?
I do.
Their job was to prepare a preliminary study and or reports required for the project, to assist the Four Lakes Task Force with all actions as necessary and required under Part 307. Do you see that?
Yes,
So Spicer Group was involved with the Part 307 proceedings, wasn't it?
yes,
And do you recognize the name Ron Hansen, Mr. Sturdivant?
yes,
He was Spicer Group's engineer, right?
yes.
So he actually testified at the Part 307 proceeding, didn't he?
Um, I guess, yes, I wasn't looking for the fact he did, so.
In any event, Ron Hansen with Spicer Group. He was the expert engineer who helped prepare the lake level report that the county submitted to the court in the Part 307 proceeding, didn't he?
That's my limited understanding of what he provided.
And Ron Hansen and Luke Trumbull, didn't you review emails where they communicated extensively about the dam's lack of spillway capacity?
Yes,
So Mr. Trumbull, he did communicate about the dam's lack of spillway capacity with the engineer who is appointed by the counties to be involved in the Part 307 proceeding, didn't he?
yes,
The counties in their petition to the court, didn't they identify the lack of spillway capacity as a concern at the Edenville Dam?
can you ask that question again, please?
When the counties filed their petition in the Part 307 proceeding with the circuit court, didn't they identify the Edenville Dam's lack of spillway capacity as a concern?
I'd have to see it again to verify that.
Amy, could you bring up? Thank you. Amy, could you bring up Defendant's Exhibit 27? Do you recognize this, Mr. Sturdivant, as the petition that the
Yes.
county filed in the Part 307 proceeding?
Yes,
Amy, could you go to paragraph, here, why don't you just go through? Yeah, keep going down. So why don't you stop at paragraph 14 and then we'll go to 18. So if you could magnify paragraph 14 of the petition. The county, in its filing with the circuit court, noted that the Edenville Dam was completed around 1925 and that FERC safety inspections reports disclosed that the present condition of the dam and spillway require repairs. Do you see that?
Yes, there were concrete repairs that they outlined too.
And then Amy, could you go down to paragraph 18?
Can you hold on?
Oh,
Just a
yes.
sec, sorry. What page are you on, please?
Page 4 of Defendant's Exhibit 27.
Mrs. Minor, not Mrs. Minor, Mrs. Tommett, was at the beginning of the trial last week, I think on Monday, even after Monday, she said, or Monday and Tuesday, she goes, "Are you looking at the digital exhibits the lawyers have given you?" I said, I'm trying to, she goes, "Judge, you really need to work on the digital exhibits. You really," and so she asked me that at the end of each day. And so I'm trying to follow her outstanding leadership as I should in everything, but particularly in my job as a judge. So it took a minute. I was in the plaintiff's exhibits. I'm like, where's 27? It's not there. Like, oh yeah. Sorry, sorry, all lawyers and all members of the public watching. I wish I were better at electronics than I am. But anyway, I'm with you now.
Thank you, Your Honor. We're now on page 5 of Defendant's Exhibit 27. And Amy's magnified paragraph 18. So in this petition to the circuit court, didn't the counties explain that the Edenville Dam didn't satisfy the federal spillway capacity standard, right?
Yeah, that's correct. Doesn't say anything about the 315 requirement to pass half PMF.
And you saw the county resolution previously that said that Spicer Group would prepare a lake level report for the court. Do you remember that?
Yes,
Let's bring up that report. It's Defendant's Exhibit 4-6. Do you recognize this report, Mr. Sturdivant?
yes, I do.
It was prepared by Spicer Group. And let's go to page 6.
Before you proceed, can you just give me a minute to make a couple of notes?
Yes.
Thank you.
Amy, could you go ahead and magnify that? Thank you.
Okay, go ahead.
On page 6 of this report, Mr. Sturdivant, Spicer Group reports to the court about how the Four Lakes Task Force met and coordinated with the MDEQ dam safety staff. Do you see that?
Yes,
And it reports that repairs and improvements will need to be made at the dam. Do you see that?
I do.
And then in the middle, it says the preliminary conclusion is it should be anticipated that modest improvements to spillway capacity at Wixom Lake and Secord Lake will be required, and that repairs at all 4 dams will be required. Do you see that, Mr. Sturdivant?
I do.
And it further reports that in general, signs of instability or structural fatigue have not been observed, but repairs and maintenance are needed. Do you see that?
Yes,
So Spicer Group reported to the court that the preliminary conclusion was that there would need to be an improvement to the dam spillway capacity at Wixom Lake, right?
Yes,
The Spicer Group, they still recommended, didn't they, that the normal summer level of Wixom Lake should be maintained in the meantime?
yes,
They said that well, let's just go to the page. Let's go to page, well, first let's go to page 10, Amy. So could you magnify that top highlight hazard potential classification? Can you see this okay, Mr. Sturdivant?
yes,
So in this paragraph, Spicer Group reports to the court that the Edenville Dam is classified as having a high hazard potential due to the impact that a potential failure could have on downstream developments. Do you see that?
yes,
And I believe you testified in September of last year that a hazard classification of a dam is unrelated to the condition of the dam. Is that your understanding?
that's correct.
So just because a dam is high hazard does not mean it's in poor condition, right?
No, it means it's likely to kill people if it fails.
And in any event, this information was provided to the circuit court, wasn't it?
Yes,
Amy, could you go down to page 15? Actually, I think I meant the next page. Give me just 1 second. Oh, page 14, excuse me. Yes, could you magnify all of that? Thank you. So Spicer Group reports to the court about the expediency of the normal level project. Do you see that?
yes,
They report that the implementation schedule is to operate normal lakes levels in 2019 as soon as possible, to implement necessary repairs and improvements on all 4 dams by 2023, and to complete acquisition of all assets by 2024. Do you see that?
yes,
And then in the bottom highlighted area, when it refers to Wixom Lake, it says for Wixom Lake, the objective is to achieve the normal level within 45 days of the court order. Do you see that?
yes,
So the Spicer Group was advising or recommending maintaining the normal level, even though the spillway capacity of the dam had not been increased, right?
yes. I guess I'm a little confused here. I didn't understand that Spicer had regulatory authority over the dam or 315.
You haven't been involved in a Part 307 proceeding, right, Mr. Sturdivant?
I understand the recommendations made by the consultant that's directed to do this work, yes.
And under Part 307, are you aware of any requirement in Part 307 that requires the state agency, whether it's Eagle or DEQ, to advise as to the wisdom of a recommendation by a county's appointed engineer?
I have not seen that directly in writing, no.
This just isn't an area you practice in, right?
Very similar.
Let's go down to, actually, we'll save that for later. Thank you, Amy. Amy, could you please bring up plaintiff's exhibit 151? Mr. Sturdivant, do you remember Mr. Thompson asking you questions about this email last week?
Yes,
And if you see at the top there, this is an email from Luke Trumbull to Brian Rudolph. This is plaintiff's exhibit 151. And Luke Trumbull's long paragraph talks about essentially flow rates at the dam. Do you see that?
yeah, yes,
And this is in April 2020. It's about the draft refill permit for Wixom Lake, right?
all right, these are environmental concerns.
Right, environmental concerns. And Mr. Thompson, he asked you to assume that Mr. Rudolph had asked Mr. Trumbull in an email what dam safety concerns Mr. Trumbull had, if any, about the April 2020 refill permit. Do you recall that?
Yes,
But Mr. Rudolph, he didn't actually ask that question of Mr. Trumbull, did he? Can we go down to
I'd
the,
have to go back and review it.
can we go down to the next page, Amy? So could you magnify that, that area? So what Mr. Rudolph asked of Luke Trumbull, he said, Luke or Dan, do you have any thoughts on the release rate increase? Do you see that?
Yep, yes,
So he was asking about the flow rate identified in the draft refill permit, right?
yeah, sure, because
So he
different flow
didn't
rates
actually,
can cause different damage downstream, and whether or not the deteriorated concrete was, if it was acceptable to discharge that much water over that, and different safety concerns related to the actual discharge.
so Mr. Thompson asked you to assume that Mr. Rudolph asked Luke Trumbull about dam safety concerns. That was his question, right?
About the release increase, yes.
No, Mr. Thompson asked you to assume Mr. Rudolph was asking Mr. Trumbull about dam safety concerns. That's what he asked you to assume, didn't he?
Yes,
But that's not what Mr. Rudolph actually asked Mr. Trumbull, is it? He asked him about the release rate increase, right?
yes,
So when you read the question that Mr. Trumbull was being asked, Amy, could you go to the first page again? Mr. Trumbull's discussion of environmental concerns in the release rate, it makes sense, doesn't it?
does what makes sense?
That Mr. Trumbull was answering the question that Mr. Rudolph asked him about release rates.
Yeah, I guess I was referring to the second part of that sentence on the one you just showed me. The second sentence.
The second sentence we're looking at right now?
No, and the one there you go.
Where he talks about incorporating comments from the second paragraph of Jeff's letter?
Okay, I misinterpreted when I just read it
No, that's
specifically.
fine. I'm not asking you about that sentence, but Mr. Trumbull, he was just answering Mr. Rudolph's question, wasn't he?
Yes,
Now, Amy, you can take that down. Mr. Sturdivant, you testified last week that Eagle abused its power by granting Boyce Hydro's application to return Wixom Lake to its normal level. Do you recall that?
yes,
I believe your testimony was that Eagle should not have granted that application because the dam lacked sufficient spillway capacity, so that by granting it, that was an abuse of authority. That was your testimony?
yes,
That application just wanted to set Wixom Lake to the same level the dam owner had always set it in the spring while it was under FERC jurisdiction, right?
yes,
And that FERC license had been in place for 20 years between 1998 and 2018, right?
yes,
And so the lake had been set at that level each spring for at least 20 years, right?
yes,
And during that time, the dam had always lacked spillway capacity, didn't it?
yes, it did.
But FERC actually mandated that the dam owner maintain that normal level, didn't it?
It did.
From a regulatory perspective, Mr. Sturdivant, mandating an action is different than simply authorizing an action, isn't it?
They're one and the same to me.
So if a regulator orders someone to do something they don't want to do, in your mind, that's one and the same with simply authorizing someone to do something they asked permission to do.
I wasn't including the condition that they didn't want to do it.
So, okay. So let's say the Eagle had granted a permit application for someone to build a dock.
Build a what?
A dock,
Dock.
yes,
So something we attach boats to or go and fish from.
correct. right.
Okay,
Yeah.
good.
So let's say Eagle had granted someone's permit application to build a dock, and so someone gets a dock permit from Eagle. Are you with me, Mr. Sturdivant?
Yes, I am.
If that person did not build the dock that they asked permission to build, is it your opinion that Eagle could then force them to build the dock anyway?
No,
It's just someone asking for permission to do something they want to do. Eagle says yes, but they don't actually have to do it, right?
that's correct.
So that's the distinction that I'm trying to make, that from a regulatory perspective, giving someone permission to do something they want to do is different than ordering them to do it, right?
I can't draw that same line when it comes to a dock versus public safety.
Okay, so did Eagle ever order Boyce Hydro to maintain the normal summer level of Wixom Lake?
Not with reference to this part of the case, no.
At what part of the case did Eagle order Boyce Hydro to maintain the normal summer level of Wixom Lake?
That comes later. This was just the prime opportunity to keep the water level down and in the interim until the dam was upgraded the way it needed to be upgraded.
Okay, I guess I'm not understanding your answer. Is it your testimony that at some point Eagle ordered Boyce Hydro to maintain the normal summer level of Wixom Lake?
Not with what we're talking about now.
Okay. Is this explain the qualification that you keep putting on your answer. Did Eagle ever order Boyce Hydro to maintain the normal summer level of Wixom Lake?
No, the circuit court did that.
Eagle did not issue that order, did it?
No,
And as far as you know, in Michigan, lake level proceedings are handled by the circuit courts, usually by petitions filed by counties, right?
yes,
Is it your opinion that the Federal Energy Regulatory Commission abused its authority by requiring Boyce Hydro to maintain the normal level of Wixom Lake?
yes,
Is it your opinion that anywhere in the country where a hydro dam does not have sufficient spillway capacity, FERC is abusing its authority by requiring those hydro dam owners to still maintain normal operating levels? Is that your opinion?
it depends on the extent, yes. It is my opinion, and it's case dependent on whatever dam you're dealing with and what threat it poses. And there's a lot of pieces to that puzzle. So I
So
can't answer a blanket yes.
So even if a dam lacks sufficient spillway capacity under FERC's jurisdiction somewhere in the country, whether FERC requires that dam owner to modify the normal operating level of the impoundment is specific to each situation. Is that what you're saying?
Yes,
Amy, could you bring up P104? Your Honor, I see it's 12:02. Because of our late start, did you have a different schedule in mind? We're open to
I
a shorter
sorta
lunch break,
did.
but
Yeah, so let's talk about that. Thank you for bringing that up. How much longer do you think you have on Cross?
probably about 2 more hours.
Okay. How much do we think on, redirect?
45 minutes to an hour. No, indeed, Your Honor, Mr. Sturdivant has a stop at 4 p.m. our time. I haven't determined if it's a hard stop or a desired stop, but he did mention 4 o'clock our time is going to be late to stop.
I'm smiling, Mr. Sturdivant, because I'm thinking of likes and wants, not because of anything. Are you at 4 o'clock Eastern, 2 o'clock Mountain Time? Are you a hard stop or, I'd like to stop?
It's a hard stop, Your Honor. It has to do with the contract release.
Oh, that's fine. I knew the risk I took letting you leave the door. So I understand. Okay, so if we take, here's what I'm thinking. Are you gonna have do you think you're gonna have recross after Mr. Sturtevant? I'm guessing you probably will.
Possibly, yeah. Yeah, I mean, my hope is to get through Mr. Sturdivant today. And so we would be open to a truncated lunch break, but we don't want to interfere with other people's plans. So-
Okay. That'll be my hope as well. All right, so here's what I'm going to do. First, let me consult with the most important people for me right now, and that's Ms. Husa and Ms. Heacock. So, and not that Dan isn't important, I'll ask him too, but what are you thinking? If we took 30 minutes for lunch, would that be? Okay, all right,
Then it-
we're gonna do, let's see, I got it. Okay, I want to do 30. So, okay. We're gonna take a break. It's gonna be 30 minutes. This is gonna be our lunch break and our morning break. We'll start back up at 12:20, 12:35, 12:35. Elizabeth, is that gonna be okay for you? Dan, you okay with that? Dan?
Yes.
Mr. Sturdivant, will that work for you?
Yes, Your Honor, thank you.
All right, and then we'll reconvene. If we have to take we'll probably have to take a health and comfort break at some point after Mr. Gamble's cross would probably be a good time. It's not gonna be 15 minutes, it's gonna be like 5 or 7 minutes. So if you need, like me, if you're hypoglycemic, either buy some candy bars or get somebody to buy some for you, or come back and I'll give you some stuff. But I would really like it if we could have Mr. Servant's service in this case completed. If we can't, we can't. That's so be it. I mean, he's providing very important testimony for both plaintiffs and defendants, and I understand that. So we're in recess, Mr. Sturdivant. We'll see you in 30 minutes. Thank you.
Thank you.
Goodbye.
All right, fair.
Three, four. Ready?
No, I'm not.
Yes,
We're taking Mr. Stern at 4 o'clock today.
hopefully, or sooner.
Before sooner, our preference is to start with Dr. Marr first thing tomorrow. Does the court, is that okay with the court, or we can finish tomorrow with our proofs if we start Dr. Marr first thing in the morning? As opposed to having him go over the stall for.
I know you've indicated, I know we all do want to move it. I will tell the attorneys candidly, I have I've set a 5 o'clock Zoom conference with two of my Court of Appeals colleagues on a case that we've been working on since November today. So for me to have 60 minutes to try to prepare for that Zoom conference would be a really good thing. So I would not mind, it's just, it's an elections case. All of our cases are important, but there's some issues of first impression and we're not entirely sure what we're going to do yet. And, anyway, it would be helpful for me. So
Okay.
with that.
This government's still, I wanted to hear him object to it.
Okay. Mr. Juan, he may be younger than us, but he seems like a pretty quick study. Sturtevant, you're in Colorado. You probably have less snow and warmer temperatures than we do, and you're still under oath. So
I won't tell you then that it's 45 degrees, perfectly sunny then.
nice. And didn't your guys win their football game?
Yes,
Ah,
moving on.
okay, good. Is that a home game for you all?
Yes, the next one is.
Oh, wow, nice.
Tickets were advertised. The good tickets are starting at around $3,500 up to $7,500.
Okay,
And
so you're
there's some,
like 4 or 5 of your closest friends and.
yeah,
Yeah, I heard that the tickets, for yesterday's game in Miami were going in the 4,000 range and it was the highest ever. So, which I did not know. IU has the largest alumni base of any college in the country, which.
I didn't know that either.
What? So, who knew? Now they have a football championship.
They do.
All right, enough frivolity. I'm sorry for,
I know.
it's my bad.
Before we forget, if the IT person is listening, could they promote Amy Metasinka as a panelist so that she could share? She just needs to be
Oh,
promoted.
great
as a
IT
panelist.
helpers.
There you go. MDAG. Yep.
Okay,
Excuse me.
all right.
Mr. Sturtevant. Well, Amy, let's bring up P104. I know when you get a chance, it'll be okay. So this is P104. Plaintiffs 104. Well, as Amy's bringing this up, Mr. Sturtevant, do you remember last week, Mr. Thompson showed you the Part 315 report that Spicer Group prepared and delivered to Eagle after the dam failed? Do you remember that, Mr. Sturtevant?
Yes.
And I believe you testified last week that you thought it was inappropriate for Eagle to grant the April 2020 permit application from Boyce Hydro prior to receiving that Part 315 report. Was that your testimony?
Yes, yes, it was because they didn't have a firm determination on the half PMF and the fact that the spillway could not pass it.
The report did not state that the normal water level of Wixom Lake was dangerous, did it?
It did not.
And the report did not advise that the lake needed to be drawn down until the half PMF spillway capacity could be increased, did it?
No,
Spicer Group, they're the one who advised the circuit court and the Part 307 proceeding to still maintain the normal level despite the lack of spillway capacity, didn't they?
they did.
So that report simply confirmed that the dam lacked spillway capacity, right?
It did.
But Spicer Group and Eagle, or at least Spicer Group, they already thought that the dam lacked spillway capacity. Isn't that your understanding from the review of the documents?
It is.
Amy, are you able to bring up any documents? Can you just bring it up outside of trial director?
Yep.
While we're waiting on that, just on scheduling, just so the parties are aware, on Thursday at 12:15 PM, I have a status conference in another court of claims case. It'll be off the record in chambers, but it's a newly filed case, and if at all possible, I'd like to at least have 15 to 30 minutes to talk with the lawyers. So just as a heads up, if we're working around witness schedules, Thursday, 12:15, I would be very grateful if I could be in my chambers for 15 to 30 minutes.
Of course.
Thank you.
Mr. Sturdivant, do you recognize this as the report we were just talking about?
Yes.
Amy, can you go down to page 19? Actually, scroll one page up. So do you see at the top that it has these pictures and it's at the Edenville Dam on the Tittabawassee side? Do you see that?
Yes.
So I thought we could look at some of these pictures. Amy, could you go back down to page 19 of the exhibit? And so Amy, even though you can't magnify, can you zoom in a little bit and we'll look at those bottom two pages or some of those pages?
Campbell, could I have just a minute? I'd like to get the original.
Yes. Could you scroll down just a little bit? Okay, that's fine.
That's the number again.
Plaintiffs 104.
It's the inspection report.
Yes.
Thanks.
Sure.
Ready?
So Your Honor, you, or Mr. Sturdivant, these are could you scroll down just a little bit so he can see the caption on those bottom two? Mr. Sturdivant, these are the seepage tile and drains on the left embankment. Is that right?
That's how they're labeled. Yes.
Okay. And so, Your Honor, I just thought it'd be helpful to show you, because I think the court had asked questions about what a drain looks like. And so these pictures on the bottom here, those are what the drains look like on the Edenville Dam, the left embankment.
And that's page 2 of photograph number 8.
Yes, that's page 19 of the exhibit.
Right. Good.
And Amy, could you go down to page 27 of the exhibit to look at what the gates look like? So like on the, Mr. Sturdivant, do you see the number 38 Tainter Gate?
Yes,
And I believe that's the Tainter Gate that you described the last time you were on the stand with Mr. Thompson. Is that right?
yes,
And you can see the chain that attaches to the top in order to lift the Tainter Gate and allow water to travel beneath it, right?
yeah, they're attached to, that's attached to the bottom with the yoke.
Oh, okay. And the machinery there, like the orange trailer, that's the hoist that lifts the gate, is that right?
That's, yes,
Okay. Yeah, no, that's on page 27 of the exhibit.
And I'm sure it's in the exhibit. When are these photographs? Were they all taken the same day? That's the first question. If anybody knows.
These were taken by Spicer Group and they say that they did their inspections between 2019 and 2020. So I don't know if they were the same day, but it was certainly not the winter time because you can see
Right.
some of them have trees or leaves on the trees and some don't. Oh yeah, I can see they probably weren't the same day. That seems pretty plain.
All right, but these are before May 19th, 2020.
Yes.
Thank you.
Yep.
And did the plaintiffs agree that they're sometime between 2018 and May of 2020?
Between 19.
19 and 20. Okay, great. Thank you.
Yeah. So this is prior to the dam failure. We just thought it'd be helpful.
No, it's
Your
very
Honor.
helpful. Pictures worth 1,000 words, is this the poets say.
And then Amy, could you go down to the next page, 28? And Mr. Sturdivant, do you see that top right photo? That's the downstream face of the rollway. When we keep talking about spillways, is this what we're referring to?
yes,
And so the tainter gates, they're lifted so water can come beneath them and come down the spillway, right?
correct.
Okay.
And that's photograph 42
Yes.
on page 28 of 39 in exhibit 104.
Yes. Plaintiff's exhibit 104.
Thank you.
Okay, well, I already asked you some questions about this report. I just wanted to identify those pictures for the court. Amy, could you bring up D 132, defendants 132 and trial director? D 132. And then you can scroll down one page. Mr. Sturdivant, do you recognize this as the declaration you submitted as your expert report in this case?
Yes,
Okay, let's go down to page 7, paragraph 12, Amy. Could you magnify One more page. Could you magnify that blue highlight, please? In your expert report, you say that throughout this time, the dam was under the supervision of the Dam Safety Division of Eagle. Do you see that?
I do.
Now, no, as far as you know, Mr. Sturdivant, no Eagle employee literally supervised any Boyce Hydro employees in their job responsibilities, did they?
No,
When you say supervision, do you just mean that the dam was under the jurisdiction of Part 315?
yes,
Okay. And then in the next sentence that's highlighted in blue, you say, thereby defendants exercised operational control over the dam. Do you see that?
yes.
What is the factual basis for your opinion that Eagle and DNR exercised operational control over the dam?
They set the levels on the reservoir, on the lake. Sorry if I use those terms interchangeably.
So,
And they eliminated the possibility of the dam owner to operate them outside those limits, and under their own state codes, they can move in to operate the dam if they needed to.
okay, so you provided three different data points. So the first one is you said that Eagle and DNR set the lake levels for Wixon Dam. Which document, or excuse me, for Edenville Dam, which document are you referring to when you say that Eagle and DNR set the lake levels for Wixom Lake?
307.
You mean the 307 order from the circuit court?
Yes, they had the authority to chime in and say something.
So is there any other document you're referring to when you say the Eagle and DNR set the lake level for Wixom Lake?
Not offhand.
And then the second data point that you identified is you said that Eagle and DNR eliminated the ability of the dam owner to modify the level of Wixom Lake. Is that what you said?
The way I read the order is that they couldn't do anything outside of those levels without going through the circuit court and through the red tape involved.
And when you say the order, you're referring to the Part 307 order?
I am.
Okay, is there any other document you're referring to when you say that Eagle and DNR eliminated the ability of the dam owner to modify lake levels?
I can't think of one offhand.
Okay, and then I think you said a third thing, Mr. Sturdivant, but my memory is escaping me for why you think Eagle and DNR exercised operational control over the dam. And I think you said that it's because it was under Part 315 jurisdiction. Was that it, or was it something else?
Yes,
Okay. So in your opinion, it was enough for the dam to fall under Part 315 jurisdiction and have a Part 307 order in place. So in that situation, Eagle and DNR exercised operational control over the dam. Is that what you're saying?
yes.
And you're not an expert in Part 315, are you?
I'm familiar with the code.
But you haven't been qualified as an expert in Part 315 of Michigan law, have you?
I don't think that was part of the previous hearing.
And you've never regulated a dam in Michigan, have you? Just in Wisconsin and Colorado?
I don't regulate dams in Colorado, only my own. But yes, in Wisconsin, and the law is really not all that different.
But you haven't regulated a dam in Michigan?
I have not. It pretty much follows the national dam safety standards.
So are you aware that there are other dams in Michigan that are regulated both by Part 315 and have a Part 307 order in place?
Yes,
So is it your opinion that Eagle and DNR operationally control all of those dams?
Yes, and they certainly can.
And when you say they certainly can, you mean that Eagle and DNR can take over the dam from the private owner? Is that what you mean?
For the purposes of what's outlined in 315 that gives them that authority.
But Eagle, it didn't use that authority in this situation with the Eatonville Dam, did it?
Not by going on the property and controlling the actual gate operation, no.
Amy,
They should have ordered it? Yep.
Amy, could you bring up P154, Plaintiff's Exhibit 154? Mr. Sturdivant, do you recognize this as the permit from April 2020 that Eagle gave to Boyce Hydro to conduct refill activities at the Eatonville Dam?
Yes.
Were you in the court to hear Mr. Trumbull's testimony, Mr. Sturdivant?
I'm not sure I heard all of it, but yes, I was.
Did you hear Mr. Trumbull testify that under Part 315, dam owners can take measures they see fit to address emergency problems at a dam?
Yes.
Do you have any basis to disagree with Mr. Trumbull's testimony of what Part 315 authorizes dam owners to do?
No.
Amy, could you go down to maybe 2 pages down to page 3? Okay, one more, page 4. Oops, back to page 3, sorry. Amy, could you please highlight or magnify paragraph 9? Mr. Sturdivant, do you recall last week that Mr. Thompson showed you this paragraph from the permit? Does that look familiar?
Yes.
And that last sentence, it says the issuance of this permit in no way authorizes any future drawdown of the water elevation of Wixom Lake below those levels, unless done so pursuant to an order or permit issued by this department. Do you see that?
Yes.
Are you aware, or I guess, let me back up. Are you familiar with Part 301 of Michigan statutes?
That was the authorization or the statute that authorized the raising of the level from Runner River.
And have you ever administered Part 301?
No.
And are you aware that under Part 301, a permit is required for someone to diminish an inland lake, Mr. Sturdivant?
I did see that, yes.
And this statement in this permit, it simply says that future drawdowns will require an order or a permit issued by the department. Isn't that right?
Yes.
And under Part 301, they would need to get a permit to diminish an inland lake, wouldn't they?
I would hope not in an emergency situation, or even, for an emergency situation, or if they choose to do so.
But in the ordinary course of business, outside of emergencies, under Part 301, people need a permit in order to diminish an inland lake, right? As far as you know?
As far as I know, unless it's not ordered by another entity.
And this statement in the permit conditions, Mr. Sturdivant, isn't it simply restating that expectation that Boyce Hydro would get a permit before doing future drawdowns of Wixom Lake?
Yes,
Amy, could you go back up to the first page? Now, Mr. Sturdivant. Mr. Sturdivant, this is not an order from Eagle. It's just a permit, isn't it?
that's how it reads, yes.
So as far as you know, this permit was not requiring Boyce Hydro to do anything. It was just giving Boyce Hydro permission to do something they asked to do, right?
Yes,
And Boyce Hydro, they did not actually have to carry out this permit, as far as you know, right?
I guess I don't know the answer to that, whether the 307 permit would have governed or order, the court order.
If Boyce Hydro had not carried out the requirements of this permit, is it your belief that Eagle or DNR could have forced them to do it?
That is my impression, yes.
What is the basis of that opinion?
The 307 water level order that the circuit court said has to be up by that certain time.
And you understand that that Part 307 order was obtained by the county governments in Gladwin and Midland County, right? Not Eagle or DNR. Do you understand that, Mr. Sturdivant?
Yes,
Okay. Amy, let's go to defendants 132. Defendants exhibit 132. Mr. Sturdivant, let's go to a phrase that you use several times in your declaration. Amy, can you start at page 19? And could you just magnify the yellow, not the purple? Thank you. Mr. Sturdivant, in your declaration, you say that the decision to authorize and in fact force the owner to elevate water levels despite these warnings was an abuse of power. So the phrase that I'm interested in is the word force. Is it your opinion that Eagle and DNR forced the owner of Wixom Lake to elevate water levels at the Edenville Dam?
it is.
What is the basis of your opinion that Eagle and DNR forced Boyce Hydro to elevate water levels?
They would have had to bring those water levels up to summer levels anyway, without a specific special permit. So not keeping that water level down, not telling them to keep it down is forcing them to raise it.
Okay. So what document are you referring to when you say that Eagle and DNR forced the dam owner to elevate water levels?
Just the fact that by not requiring the lake to remain at run of river was forcing them to raise it otherwise.
Okay, and so I had asked you to identify a document and you didn't identify any documents. Is that because you're not aware of any documents in which Eagle and DNR forced the owner to elevate water levels at Wixom Lake?
No, the actions.
So sorry, just to be clear, to avoid that double negative, there are no documents you know of in which Eagle and DNR force the owner to elevate water levels, right?
Correct.
And well, let's just show you one more example of that. Amy, let's go to page 15, paragraph 6. So if you could magnify that highlighted section there. Yeah. So, Mr. Sturdivant, this is just one of several times in this document where you say that the state authorized and in fact forced Boyce Hydro to elevate the water levels behind the dam. Is your testimony any different for this statement than the testimony you already provided?
It is not.
So it's your testimony that there's no document in which Eagle or DNR ever forced Boyce Hydro to elevate water levels, but by not ordering Boyce Hydro to lower water levels, Eagle and DNR were forcing Boyce Hydro to elevate water levels. Is that your testimony?
No. By not in fact just keeping the water level where it was, wouldn't have required an order to lower it any further. And it should have been kept down there.
Okay, did Boyce Hydro ever ask to keep it down? The water level?
I think it was way back in 13 that they were talking about lowering the level.
Okay, back in 2013, they talked about it. We saw some of those documents. After the dam was under the state's jurisdiction beginning in September 2018, was there any time when Boyce Hydro submitted a permit application to Eagle or DNR asking to lower water levels of Wixom Lake during the summertime?
I did not see one, no.
Mr. Sturdivant, there were 2 times while while the dam was under state's jurisdiction, when Boyce Hydro returned Wixom Lake to its normal summer level, first in 2019 and in 2020. So I'm going to ask you questions about both those years. So let's start in 2019. Amy, could you bring up defendant 32? Mr. Sturdivant, if we start at the bottom, Amy. You can see that this is an email on the very bottom from Lee Mueller to Dave Kepler on September 25th, 2018. Do you see that?
Yes.
And September 25th, 2018, that's the day that FERC's licensing revocation order went into effect, right?
That's my understanding.
And the last sentence of that first paragraph, this is Lee Mueller announcing to Dave Kepler, quote, Boyce will therefore cease Edenville operation at 11 p.m. tonight and file constructive notice of this action with FERC. And then he goes on in the next paragraph to explain that this circumstance engenders a necessary change in operations in the flow regime for the Edenville Dam spillways and reservoir. Do you see that?
Are you talking about the sentence that starts, when you have time, I would like to discuss?
Oh, no, I was just reading the first sentence in the highlighted paragraph.
Yes.
And then Mr. Mueller explains that next Monday, Boyce will be laying off approximately 50% of its staff as a result of the loss of the Edenville Dam electrical generation revenue. Do you see that?
Yes.
And that's because Boyce Hydro made its money by selling the electricity generated by the Edenville Dam. So when FERC revoked the license, they couldn't sell electricity anymore because they couldn't generate it. Is that correct?
Yes.
So they lost money and they had to lay off their staff, right?
Yes.
And then he says, when you have time, I would like to discuss potential options for obtaining financial assistance that would be required in order to retain the minimum operational staff needed to support normal water levels in the Edenville Dam Reservoir, if such an option is even available. Do you see that?
Yes.
So he's asking Dave Kepler for financial assistance to maintain the normal level of Wixom Lake, right?
If they're even going to be allowed to, yes.
Well, if such an option, such financial assistance is even available, right?
I read it as if the option to support normal water levels even existed.
All right, Amy, could you go up to the next email? And Mr. Kepler responds that same day. And he asks, on water level, want to discuss both what is needed through winter and how we bring it up in spring. We should have a plan by then. Do you see that?
Yes.
So Mr. Kepler is interested in bringing the water level up in the spring of 2019, right?
He is questioning it, yes.
And then he asks in the orange, has DEQ and DNR engaged? Do you see that?
Yes.
All right, so let's go up to the next email. Mr. Moeller responds again that same day to Dave Kepler. And first, in response to that last question that Mr. Kepler asked, Lee Moeller says there has been no interaction with either NDEQ or NDNR as of today. Do you see that?
Yes.
And then Mr. Moeller, in regards to bringing it up in the spring, he clarifies in the pink, he says, as I have previously advised you, absent the income necessary to maintain the Wixom Reservoir, the water level will be lowered to approximately 8 feet below normal pond level, which, depending on rainfall amounts, will probably be achieved in the next 30 days. Do you see that?
Yes.
Is there any indication in this email exchange that the reason Dave Kepler or Lee Moeller wanted to return Wixom Lake to its normal level was because Eagle or DNR was forcing them to do so?
No, they stayed uninvolved.
They don't mention anything about mussels or aquatic resources or anything like that, at least in this email exchange, right, Mr. Sturdivant?
Not that I can see.
Mr. Sturdivant, we previously looked at, Amy, why don't you bring up defendant 35? We looked at this earlier today. This is the county resolutions that Midland and Gladwin County passed on October 9th, 2018. Do you remember this document, Mr. Sturdivant?
Yes, I do.
So October 9th, that's just a few weeks after September 25th, right?
Yes.
So pretty soon after FERC revoked its license, both Midland and Gladwin counties, they passed resolutions to initiate the Part 307 process to establish a normal lake level for Wixom Lake, right?
Excuse me. Yes.
Is there anywhere, and Amy, you can scroll through it, or Mr. Sturdivant, if you remember, is there anywhere in these resolutions indicating that Eagle or DNR was compelling the counties to pass these resolutions?
No, I'm just not seeing where their involvement is really on the forefront, where they're actually saying don't do it.
Sorry, so you're not seeing anywhere in these resolutions where it gives any indication that Eagle and DNR are forcing the counties to initiate the Part 307 process, right?
No, no.
There's
They would have
nowhere,
the Go ahead, sorry.
there's nowhere in these resolutions where the counties are saying that because of litigation threats from Eagle or DNR about mussels, we have to initiate the Part 307 processing and get a normal lake level established. There's nothing like that in these resolutions, is there?
I don't see them. See it.
I didn't see them, what? What was the last two words?
Can you repeat, please?
No. The answer is no, not that I won't repeat it.
No, you don't see them?
That is correct.
Thank you.
Amy, could you bring up P plaintiffs 24? Plaintiffs exhibit 24. Mr. Sturdivant, this is the September 2018 revocation order from FERC. Do you recognize this document?
Yes,
Amy, can we go to page 16? So this is plaintiffs 24. And we're on page 16 of 24. And FERC notes that Gladwin County and the Wixom Lake Association had filed motions to intervene to ensure that any revocation of the license would not compromise recreational opportunities at the project. Do you see that?
yes,
In addition, the Sanford Lake Preservation Association expressed its concern that revoking the Edenville project license would enable Boyce Hydro to lower Sanford Lake, which is the reservoir for Boyce Hydro's Sanford Hydro project downstream of the Edenville project, below its minimum operating level contained in its license. Do you see that?
I do.
So these concerns summarized by FERC are related to recreational opportunities and maintaining minimal operating levels, right, of these reservoirs?
Yes,
That's consistent with the county's resolutions, isn't it?
yes,
Amy, could you bring defendants 39 up? So after and you recall earlier, we looked at the resolutions that appointed the Spicer Group as the consulting engineer for the Part 307 project. Do you remember that?
I do.
So Amy, could you highlight the first group of the to and from in that first line? Yeah, okay, thanks. This is Ron Hansen from Spicer Group to Mario Fusco at DEQ. Do you see that, Mr. Sturdivant?
Yes,
Mr. Hansen explains in that first line that the Four Lakes Task Force was tasked by resolution of the Board of Commissioners from the counties to prepare a legal lakes level study in accordance with Part 307. Do you see that?
yes,
And they explain that in the next paragraph that's highlighted, that Spicer Group's recommendation is to just establish the same lake levels that FERC had, right? With no changes to those lake levels.
yes,
And he explains in the last line of that second to last paragraph that the establishment of the legal lake level will provide security for property owners on the lake, as it will enable local government to maintain the lake levels in the event that FERC licenses are revoked or expired. Do you see that?
yes,
And Amy, could you go to the next page, please? Could you highlight the expediency? Yeah, just that one. Expediency. Mr. Hansen explains to Mr. Fusco that this is a key issue as the local community would like to have the 307 structure in place quickly. So to maintain the water levels in Wixom Lake for next summer. Do you see that?
yes,
And he also explains it's our current understanding that spillway capacity of the Edenville Dam is adequate to meet Part 315 requirements. Do you see that?
yep, later to be found in error.
Right. Spicer changed its mind later after it did further analysis, right?
Yes, and yes,
Okay. So at this point, Spicer is expressing that the local community wants Wixom Lake back up for the summer of 2019, right?
yes,
So at least Spicer Group didn't think that because the dam lacked sufficient spillway capacity under the federal standard, that that was a reason to keep the lake level down, right?
yes, that's correct.
Uh, And when the county filed we looked at the petition earlier today already. When the county filed its petition, it noted that the dam did not satisfy the federal spillway capacity standard to the court, didn't it?
I do remember seeing something like that, yes.
And Amy, let's actually bring up defendants 27. So here's the petition we looked at earlier today. Amy, can you go to paragraph 38? Not sure which page that is. Oop, up one more. One more. So page 9 of defendants exhibit 27, paragraph 38. Thank you. So in paragraph 38, the counties, they explained to the circuit court that they thought maintaining the same level at Wixom Lake that had always been maintained under the FERC license, quote, best protects the public health, safety, and welfare. Do you see that?
Yes,
And at the end, it says, further, it best preserves and protects the value of property around the lake, all as envisioned by Part 307. Do you see that?
I do.
So Spicer Group, who was the engineer that the counties appointed to consult on this issue, they were involved in presenting to the court information that maintaining the normal level of Wixom Lake would protect public safety and property value, right?
That's what they said here, yes.
Is there any indication in this petition that the counties filed that they were filing the petition because Eagle and DNR were threatening them about mussels or litigation?
No, it's just the folks responsible for administering 315 should have caught this and said, there's no way this is a safer arrangement. The dam does not meet 315 requirements for spillway capacity.
Okay, let's go to defendants exhibit 43. So you can see that this is an email dated March 4th, 2019 from Lee Mueller to Ron Heilig and Greg All. Do you know who Ron Heilig and Greg All are, Mr. Sturdivant?
No, only that they're associated with Boise Hydro.
Okay, so you can tell from the email addresses that they're Boise Hydro employees, right?
Correct.
Amy, could you magnify that middle highlighted portion? Thank you. So in this internal email among Boise Hydro employees, Mr. Mueller explains that in March 2019, that the Edenville Dam Reservoir will probably be at the current lower water level for the next 6 months until there's a restoration of the FERC license or the counties come up with a financing plan to allow Boise to operate the Edenville spillway gates for water level restoration. Do you see that?
Yes.
Okay, Amy, you can drop the magnification. So Mr. Mueller, he says he's going to keep the lake level down until he gets the FERC license back or the counties come up with a financing plan, right?
Yes.
He doesn't indicate anywhere in this email, as far as you know, that the reason he would bring up the level of Wixom Lake in the spring of 2019 was because he was being threatened by Eagle or DNR about mussels or aquatic resource damages, right?
Not in this, no.
There's no email correspondence with Lee Mueller prior to the failure of the dam in which he explains that the reason he's going to return Wixom Lake to its normal level is because of threats of litigation about mussels, is there?
No.
Amy, let's go to defendants exhibit 46. You remember we looked at this earlier today, right, Mr. Sturdivant?
Yes,
This is the lake level report.
yes,
Amy, let's go down to page 85. So in the appendix to this lake level report, Spicer Group attached letters of support it received from people who lived on the lakes. Do you remember reviewing any of these documents, Mr. Sturdivant?
yes,
So at this point, during the Part 307 proceedings, Boyce Hydro still hadn't returned Wixom Lake to its normal level, right? It was still low.
yes. That's the impression I get from the complaint and the photograph.
So let's just read through some of these complaints. You see that this is a letter from someone named Leo Walt. And he says in that second paragraph that as 60-foot waterfront stakeholders, we want to enjoy lake activities like swimming, boating, and fishing. This isn't possible today with the current lake water level 8 feet below the level at which we purchased our recreational getaway. And in this letter, they support returning Wixom Lake, or they support the efforts to establish the normal level of Wixom Lake, right?
Yes,
Okay, let's go to the next letter, Amy. Next page down. So could you magnify that a bit, Amy, the whole thing? So this is a message from Sean Walsh addressed to Honorable Judge Karras. He's expressing support for returning Wixom Lake to its normal level. He explains in the second sentence, we believe that establishing lake levels, legal lake levels in the 4 lakes will benefit all of the people who live in the lakes communities. Do you see that?
I do.
He says families here rely on the lake's levels for our quality of life, for the successes of our business serving our communities and visitors, for our property values, and thus our local government's revenue. Do you see that?
I do.
He says, without the enactment of Michigan legal lake levels, the livelihood of all of our families in our lakes communities will be at risk. Do you see that?
Yes, I do.
All right, Amy, let's go to the next letter. Here's a letter from, oh, could you go to the next page down so we can see who it's from? This is Joseph Sepsi in Midland. And he's writing to express his support of establishing the normal level of Wixom Lake, right?
Yes,
Amy, could you magnify the second and third paragraphs? No, the second and third. Starting with sadly. Yep, thank you. He explains that over the past few years, he and others that depend upon Wixom Lake have effectively been held hostage by the antics of Boyce Hydro and its management team. Do you see that?
yes,
And he expresses support for getting the special assessment district established to assure the future of Wixom Lake and secure the recreational and business benefits that Wixom Lake provides to the residents of Midland, Gladwin County, and the surrounding areas. Do you see that?
I do.
Okay, Amy, let's go to the next letter. It's a little harder to read. Let's go to the next one after that.
I can read cursive.
All right, and you've got another letter, this time from Stryker's Lakeside Marina. Do you see that, Mr. Sturdivant?
I do.
Okay, and he highlights the rippling economic impact of no lake water. Do you see that bold statement there, Mr. Sturdivant?
Yes,
Okay, so in this Part 307 report, do you remember seeing any letter from anyone opposing the establishment of the legal lake level on Wixom Lake?
that would be highly unusual. So no,
And consistently, the views expressed by those who wrote in to support were concerns about maintaining their property value, right?
Yes, they obviously didn't know the risk.
And they wanted to maintain recreational and aesthetic benefits of Wixom Lake, right? That was basically their concerns generally expressed, right?
Yes,
So the fact that people were interested in getting their lake level back to where it normally would be in the summer of 2019, that's consistent with your views, isn't it?
could you repeat that, please?
Well, let me rephrase the question. Do you remember testifying in your deposition that you believed that a main reason that the counties were returning Wixom Lake to its normal level is because people who lived in the counties wanted that? That's the pressure they were putting on their political leaders, right?
Yes,
Amy, could you bring up Exhibit D135? Mr. Sturdivant. Could you go to page 50? We'll highlight some of your testimony from your deposition. Oh, page 49, excuse me. Amy, can you just magnify lines 19 through 23 first? In your deposition, you were asked, so you think the counties filed the petition because the Michigan Department of Natural Resources pressured them to do so for the sake of mussels? And you answered, I think that was part of it. Yes. Do you see that, Mr. Sturdivant?
yes,
Do you still think that's why the counties filed their petition? Was because the DNR pressured them to do so for the sake of mussels?
I think that there is definitely one piece to the puzzle.
Okay, what is the factual basis for that belief?
Many, many years of experience and the fact that mussels did come up.
Okay, what document are you referring to when you say that the counties filed their petition because the Michigan Department of Natural Resources pressured them to do so for the sake of mussels? What document are you referring to?
I can't reference a particular document.
It's just that your experience in Wisconsin leads you to believe that that must have happened here in Michigan. Is that it?
That and all the correspondence that went back and forth concerning the mussels.
Okay, what correspondence are you referring to?
Again, I can't reference the exact.
Is this correspondence between the counties and the Michigan Department of Natural Resources?
No,
Okay. Amy, could you go to page 80? Could you highlight lines 8 to 16 or magnify? So, Mr. Sturdivant, you're asking your deposition that it's your opinion that the reason Eagle didn't proactively force Boyce Hydro to permanently lower the level of Wixom Lake is because they were worried about mussels. And you answered, I don't think the freshwater mussels was the primary decision factor. And if it was like I stated earlier, negligence. Do you remember that?
yes,
So, if we go down, and could you magnify lines 17 to 23, Amy? Thank you. And you were asked, so what do you think was the primary decision factor? And you answered, I think political pressure from the riparian dam or riparian property owners around the reservoir, probably businesses in the area, but primarily the riparians and the people wanting their water levels up. Do you see that, Mr. Sturdivant?
I do.
So that testimony is consistent, at least, with the letters that we reviewed in the Part 307 report, right?
It is.
Let's go, Amy, can you bring up defendants 47? So previously we looked at, well, now this is an April 2019 email, or excuse me, letter. And you see that it's addressed to Dave Kepler and it's from Boyce Hydro. Do you see that, Mr. Sturdivant?
Yes.
And Amy, could you magnify that middle highlighted area? Oh, no, including the other highlight. Thank you. It's your, do you remember reviewing documents, Mr. Sturdivant, as part of this case in which Dave Kepler and Lee Moeller were negotiating about purchasing the Edenville Dam?
I do recall some, yes.
Okay. And Mr. Moeller is reporting to Dave Kepler about the status of the negotiations. And then in April 2019, he says in that highlighted sentence that key components of this offer include the immediate increase of the Wixom Reservoir pond level. Do you see that?
Yes.
Is there any indication on this letter, Mr. Sturdivant, that Eagle and DNR were involved in these negotiations at all?
Not through this clip, and that would absolutely shock me if they weren't.
It would shock you if they were not involved in the negotiations?
It would shock me, yes, that would, because they want a responsible owner and clean ownership of whatever it takes to operate and maintain the dam.
So is it your opinion that Eagle and DNR were involved in the negotiations between Dave Kepler and Lee Moeller to purchase the Edenville Dam?
Oh, I would certainly hope so.
Well, let me just ask the question again. This is just a yes or no question, Mr. Sturdivant. Is it your opinion that Eagle and DNR, the state agencies, were involved in the negotiations between Lee Moeller and Dave Kepler to purchase the Edenville Dam?
Again, I have not seen any documents to that.
Okay, so you haven't seen any documents confirming to you that Eagle and DNR were involved in these negotiations. Is that right?
That's correct.
Okay. Is there anywhere, and Amy, you can drop the magnification and we can scroll through this as needed, but is there anywhere, Mr. Sturdivant, that you see in this letter or any of the other documents you reviewed that the reason that Four Lakes Task Force and Boyce Hydro were negotiating the sale of Edenville Dam is because Eagle and DNR were forcing them to the table to undertake those negotiations?
No.
Is there anywhere in these documents summarizing the negotiations in which Mr. Mueller explains that the reason that he is willing to entertain returning Wixom Lake to its normal level is because he's scared of being sued by Eagle or DNR?
I do not see that here, no.
Amy, can you magnify that highlighted? So in April of 2019, summarizing the topic of their negotiations, Mr. Mueller reports that as an interim measure, Boyce Hydro will commence gradually raising the Wixom Reservoir pond level on April 15, 2019, with the goal of having the normal pond level restored in 6 weeks for the duration of the calendar year, subject to the Four Lakes Task Force agreement with this purchase offer and payment of operating and materials expenses in the amount of $50,000 per month, payable each month. Do you see that, Mr. Sturdivant?
Yes.
So Mr. Mueller's reporting that they're willing to return Wixom Lake to its normal summer level if Four Lakes Task Force pays them $50,000 a month, basically, right?
Yes.
Amy, let's bring up Defendant's Exhibit 48. Thank you, Your Honor. So on page 48, we're on page 5 of the exhibit. Defendant's Exhibit 48, page 5. And Amy, can you actually highlight just the whole email? Thank you. Or magnify the whole email. Thank you. So this is a few days later, April 12th, 2019. The subject, you can see Mr. Sturdivant, it's from Lee Mueller to Dave Kepler, and it's about negotiated purchase price details and payment schedule. Do you see that, Mr. Sturdivant?
Yes,
Mr. Mueller explains in the highlighted area, tomorrow I will prepare a detailed proposal for our planned implementation of early restoration of normal pond levels for the Wixom Reservoir, as we have discussed in the past week or so. Do you see that?
yes,
At least in this email, Mr. Mueller doesn't say anything about feeling threatened by Eagle and DNR to hurry up and restore normal pond levels, does he?
I do not see it, no.
His only reference is to negotiations between him and the Four Lakes Task Force. Isn't that right, Mr. Sturdivant?
It is.
And Amy, you can drop that magnification. And as we scroll up through this letter, first of all, Mr. Sturdivant, do you recall reviewing this email as part of your work in this case?
Yeah, early on, yes.
Okay, so throughout this letter, Amy, you can just keep scrolling. They're just discussing terms of their negotiations and potential agreement, right, Mr. Sturdivant?
Yes,
And nowhere do they mention feeling threatened by Eagle or DNR anywhere in this email exchange as a reason for them returning Wixom Lake to its normal level, right?
no,
And then Amy, could you magnify that highlighted portion? The next day, Mr. Mueller, he explains to Dave Kepler, I am now focusing on the enumeration of activities and costs that have to be undertaken for the restoration of normal pond levels of the Wixom Reservoir, as I've mentioned to you before. Do you see that?
yes,
Okay, let's pull up Defendant's Exhibit 49. So this is the agreement they reached a few days later on April 16th, 2019. Do you recognize this document, Mr. Sturdivant?
yes,
It's from Lee Mueller to Dave Kepler. It looks like it has signatures at the bottom of those two people. Do you see that, Mr. Sturdivant?
yes,
And the subject line is letter of understanding regarding acquisition of lake level assets. Do you see that?
yes,
Okay, Amy, if you can magnify the highlighted portion. Mr. Mueller says, as we negotiate the final terms and conditions of the definitive purchase agreement, we agree to transitional payments to be applied to the purchase price. And that as a consequence of this consideration, Boyce Hydro would promptly begin the process to bring up the lake level for Wixom Lake, the details of which are also set forth in attachment 2. Do you see that, Mr. Sturdivant?
yes,
So Boyce Hydro is agreeing to now promptly begin the process of bringing up the lake level for Wixom Lake, right?
yes,
And he mentions more details on attachment 2. So Amy, let's scroll down to attachment 2. Keep going. Keep going. All right, so page 5 of Defendant's Exhibit 49 is attachment 2. And could you magnify the highlighted language in the middle there? Yeah. Mr. Mueller explains to Dave Kepler, Mr. Sturdivant, do you remember reviewing this attachment as part of your work in this case?
yeah, again, very early on, yes,
Okay. Mr. Mueller basically says that Boyce Hydro will return Wixom Lake to its normal level in exchange for $40,000 a month. Do you see that?
I do,
And in the orange highlight, Mr. Mueller explains, this operational regime will be in effect until there is a closing estimated to be in January 2020 for the sale of the Edenville Dam and bottomlands to the Four Lakes Task Force. Do you see that?
Yes,
So the Four Lakes Task Force and Boyce Hydro, they had a contract in place by which Four Lakes Task Force would pay Boyce Hydro a monthly sum in exchange for Boyce Hydro maintaining the normal level of Wixom Lake, right?
yes,
Do you see anywhere in this contract that the reason they reached this agreement is because Eagle and DNR threatened to sue them about mussels?
not here, no.
Is there anywhere that you saw prior to the dam failure in which Lee Moeller at Boyce Hydro or Dave Kepler at Four Lakes Task Force said that the reason that they reached an agreement to maintain the normal level of Wixom Lake is because Eagle and DNR threatened to sue them about mussels?
No,
Amy, could you bring up defendants 50? Okay, this is the same day as that previous contract, April 16th, 2019. Could you magnify? Thanks, Amy. This is from Lee Mueller, again to Ron Heilig and Greg Ohl, his employees at Boyce Hydro. And the subject, Mr. Sturdivant, is agreement to start raising pond level at Wixom Reservoir. Do you see that?
yes,
And Mr. Mueller explains to his employees, I have made arrangements with the Four Lakes Task Force to start refilling the Wixom Reservoir pond to normal summer operating levels beginning tomorrow, April 17th, 2019. Do you see that?
yes,
Amy, you can drop the magnification. There's nowhere in this email where Lee Mueller explains internally to his employees that he's doing this because he's scared the Eagle or DNR might sue him about mussels, right?
I don't see anything in here, no.
He's saying that the reason they're returning Wixom Lake to its normal level is because he made arrangements with the Four Lakes Task Force, right?
Yes,
Okay. Okay, we've talked about when Boyce Hydro returned Wixom Lake to its normal level in 2019. Now I'm going to ask you questions about when they returned Wixom Lake to its normal level in 2020. Amy, could you bring up Defendant's Exhibit 59? Mr. Sturdivant, do you recognize this press release?
yes,
And in your review on this case, you remember that in the fall of 2019, Boyce Hydro and the Four Lakes Task Force applied for a permit to temporarily lower Wixom Lake over the winter because of ice conditions. Do you remember that?
yes,
And their permit application explained that they intended to return Wixom Lake to its normal level in the spring of 2020, right?
yes,
And if we magnify the third highlighted paragraph, please, Amy. So the Four Lakes Task Force in the press release, it explains this fact. It says, right, that it says the early drawdown will not interfere with summer lake levels. Wixom Lake will return to the normal summer level by the time the surface water temperature reaches 39 degrees Fahrenheit in spring 2020 in accordance with the Part 307 order. Do you see that, Mr. Sturdivant?
I do.
And that's consistent with your testimony earlier today that you're not aware of any time that Boyce Hydro applied to lower Wixom Lake permanently throughout the summer, only during the winter, right?
Correct.
So according to this press release, their plan from the beginning of this application process in September 2019 was to return Wixom Lake to its normal summer level in the spring of 2020, right?
Yes,
So if Eagle had granted the application, Mr. Sturtevant, Boyce Hydro still would have returned Wixom Lake to the normal level in spring of 2020, right?
Yes,
Boyce Hydro didn't do that, did they? They actually, or excuse me, Eagle didn't grant the application, did it?
For the winter drawdown.
Yes, for the winter drawdown. Sorry.
Everybody understands. I just wanna-
yeah, I don't get that one.
Oh, sorry. So when Boyce Hydro and Four Lakes Task Force applied to do this temporary winter drawdown in the fall of 2019, Eagle actually denied that application, right?
That's my understanding.
But Boyce Hydro did the drawdown anyway, didn't they?
Yes,
And then Eagle sent them an enforcement notice asking them to return Wixom Lake to its winter operating level, didn't they?
that's my understanding.
But Boyce Hydro ignored that enforcement notice too, didn't it? It didn't change the level of Wixom Lake, did it?
No,
So that enforcement notice didn't have any impact on the level of Wixom Lake at all, right?
it doesn't appear to have, no.
And then when spring arrived, Boyce Hydro, Four Lakes Task Force, they applied for a permit to return Wixom Lake to its normal level in the spring of 2020, didn't they?
Yes,
And Spicer Group was a consultant on that application, wasn't it?
yes,
They knew, as far as you're aware from the documents you've reviewed, as of February 2020, that the Edenville Dam lacked sufficient spillway capacity, right?
yes,
But they were still on the consultant on the application asking to return Wixom Lake to its normal level in the spring of 2020, right?
yes.
Amy, could you bring up plaintiffs 148? This is plaintiff's exhibit 148. It's the February 2020 refill application. I think we've looked at this a few times in this case, but do you remember reviewing the refill application as part of your work in this case, Mr. Sturtevant?
Yes,
Do you remember seeing any indication on this refill application that the reason Boyce Hydro and the Four Lakes Task Force were filing it is because they were scared that Eagle and DNR were going to sue them about mussels?
I do not see it right here.
Do you remember seeing it anywhere in the application when you reviewed it?
No, not in this context, no.
As far as you could tell, this application didn't mention anything at all about mussels or aquatic resources or natural resource damages, anything like that, right?
Just in the above where it talks about environmental areas and
Which
so, yeah,
you,
they were concerned. They did take into account environmental considerations.
okay, that they would take into account environmental considerations, right? Okay, so this application is just fulfilling the plan that the Four Lakes Task Force had all along from the previous fall, which was to refill Wixom Lake in the spring of 2020. Isn't that right?
Yes,
Amy, could you bring up Defendant's Exhibit 80? And go down to the next page. One more down, page 3. So Defendant's Exhibit 80, page 3. Do you recognize this document, Mr. Sturtevant?
yes,
So this is the April 8th, 2020 letter between Four Lakes Task Force and Boyce Hydro. Do you see that?
Yes.
And no state agency is copied or mentioned in this, or excuse me, copied on this letter, as far as you can tell, right?
Hold on a second.
This is Defendant Exhibit 80, page 3. Yes, this is Defendant's 80, right?
Page 4 has the way it appears digitally, at least to me, is page 4 has the logo.
Oh.
Excuse me, the color. Or page 3 of 3 does. So what are you getting? Sorry.
Up on the screen here, Your Honor. So we're looking at this April 8th, 2020 letter. It's from Four Lakes Task Force. You with this? Okay, thank you.
It's just, and I know everybody's worked very hard on this, it's just we're going so,
There's a lot.
they're about it digitally, just so when the Court of Appeals is looking at this and saying Redford has no idea how to try a case, and that may very well be true, but it just, there are at least 5, and I think 7 subfolders digitally for exhibits, and I'm really trying to keep track with them, and I'm looking at my probably 10,000 pages of printed documents, and I think I'll have a sternum injury if I get my notes. I've been trying this. I'm sorry, I'm slowing things down.
No, that's okay.
Doing my best. So Court of Appeals, and if you want to reverse after I'm done, please just tell me what to do better.
All right. So Mr. Sturtevant, this is April 8th, 2020. Is it your recollection that this letter is discussing the concerns that Lee Moeller raised about the draft April 2020 refill permit?
Right. Yes.
And Amy, could you magnify the middle, like the body of it? Thank you. And Four Lakes Task Force, it acknowledges the concerns that Mr. Mueller has raised, but it's Four Lakes Task Force that says at the beginning of the second paragraph that we believe that time is of the essence to raise the Wixom Lake level to its normal summer level. Do you see that?
Yes.
Now, this is a letter from the Four Lakes Task Force, not from one of the state agencies in this case, right?
That's correct.
Okay. And Amy, we're actually going to go back and forth between this exhibit and the next exhibit. So you might do a side by side. So exhibit 81 and exhibit 80 and exhibit. Just one second, I'll tell you. Shoot, sorry, I told you the wrong thing. I'm looking at, we're going to do a side by side with plaintiffs 154 and defendants 80. Thank you. Okay, so Mr. Sturtevant, so on the right-hand column, Amy, if you can scroll back down to the bottom. Thank you. All right, so Mr. Sturtevant, Amy, could you magnify the bottom highlighted paragraph on the right-hand side? That one, perfect. So in Defendant's Exhibit 80, it calls out specific provisions of the permit that Mr. Mueller was worried about. Do you see that?
Yes,
And Four Lakes Task Force is agreeing to indemnify and hold harmless Boyce Hydro and Lee Mueller from any claims or violations asserted by Eagle related to those specific terms. Do you see that, Mr. Sturdivant?
yes,
Okay, none of those terms listed in the letter on the right-hand side of the screen are numbers 7, 8, or 9 of the permit, right?
that's right, yes.
Okay, and so Amy, if you could go to the left-hand screen and scroll down. So I highlighted the ones that Mr. Mueller identified in his letter correspondence just to show that, and then go all the way down to the bottom. So on the right, you can see that numbers 1 and 3 are included on the ones that Mr. Mueller was worried about. But he's not apparently identifying paragraphs 7, 8, or 9, right, Mr. Sturdivant?
Correct.
And 7, 8, and 9, those are the conditions of the permit related to the Part 307 order, right, Mr. Sturdivant?
Yes,
Hold on.
Okay.
I don't have two screens, so I gotta.
Oh, sorry, Your Honor.
That's okay. I'm sure there's a way to do it. But in this lifetime, it's not gonna be apparent to me. You're right. One of my 3 kids to be here as my judicial assistant for IT. So could you please show me Planus 154, page 204?
Yes.
Thank you. Okay, okay, hold on. All right, so just so I'm on the same sheet of music, I'm going to use military phonetic letter descriptions. All right, I'm not trying to do anything other than I learned it as a young ensign, and there's little confusion over transmission over radio. Golf, Lima, Romeo, Sierra, Tango, Uniform, Victor, Whiskey, and X-ray. Those are the letters you want.
Yes, Your Honor.
Hold on, please. can't continue.
Thank you, Your Honor.
Thank you.
All right, Amy, let's drop both of those and let's bring up Defendant's Exhibit 81. And could you scroll down to the bottom, Amy? So page 3, or page 2, rather. Thank you. Well, down the very, very bottom, Mr. Sturdivant, you can see, good morning, Lee. Brian Rudolph has signed the permit, is estimating the permit will be issued today. Do you see that?
Yes,
Okay, so that's April 9th, 2020. Amy, you can zoom. And then Lee Moeller responds that same day. He explains back to Dave Kepler. Yesterday, I informed Greg Ohl to prepare for the reservoir refill on a gradual basis as the permit allowing this action was imminent. And then Mr. Mueller explains in the middle, once received, Boyce will gradually raise the pond level at the prescribed incremental rate for safe resaturation of the earthen embankment. And then he says, we will evaluate the need to pause the water level increase or slow down the rate of refill based on the potential for a spring storm event that could possibly cause significant flooding in Sanford and Midland. You see that?
yes.
So at least according to this email, Mr. Mueller did not feel constrained by the permit language to change refill plans if he thought it was justified to account for a potential spring storm, right?
Correct.
And that was prudent, wasn't it, Mr. Sturdivant?
Yes.
Okay. And then let's go up to the very, very top email, Amy. Still on April 9th, Mr. Mueller responds. The subject of this email is consultation with Four Lakes Task Force on commencing action on Wixom fill permit. He says, Dave, thanks for your message acknowledging Boy's plan for implementing the intent of the now issued permit for reservoir pond reservation. And then he says, in the last paragraph, Four Lakes Task Force will be kept informed on a current basis as to the status of the refill operations consistent with our past oral and written agreements. Do you see that, Mr. Sturdivant?
I do.
Is there any indication in this email exchange between Lee Moeller and Dave Kepler that the reason Lee Moeller is refilling Wixom Lake is because he is scared that Eagle and DNR will sue him over mussels?
No,
Doesn't mention mussels at all, right, Mr. Sturdivant?
does not.
Instead, he says that the refill operations are consistent with our past oral and written agreements, right, Mr. Sturdivant?
Correct.
Amy, let's look at Defendant's Exhibit 84. We can go down to the bottom. This is Dave Kepler to Lee Moeller. He's asking Lee for information about the lake level drop on Wixom Lake. Do you see that?
Yes.
And he's saying in the middle paragraph, it will help me with the numerous calls and misinformation I'm having to address. Do you see that?
Yes.
Okay, and so Lee Moeller responds. And he says on April 11th, that Boyce Hydro will commence the water level increase in Wixom Reservoir starting on Monday, April 13th. And then again, Lee Moeller says in the first highlighted area, he says, after that, Boyce personnel will evaluate the weather projections and estimate whether or not the same rate of fill should be continued, or if there is a possibility of a pending storm event that would dictate keeping the water reservoir down for a while longer until the danger passes. Do you see that?
I do.
Again, Mr. Mueller feels free to modify the refill of Wixom Lake if needed to address a pending storm event, right?
Yes, they have to be concerned with it because they're taking away part of the storage.
And so he didn't, as far as this email is concerned, he doesn't say anywhere in this email that he didn't feel like he could take those measures because Eagle or DNR would prohibit him from doing so, right?
I don't see any indication on here that either party was involved in this.
And then he explains in the last line that he will maintain those. He says that the reservoir rate will continue at a daily 4 to 6 inch water level increase until normal pond is achieved. And he says that will be maintained unless otherwise directed by Four Lakes Task Force, right?
Yes,
So he doesn't say that will be maintained unless otherwise directed by Eagle or DNR, right?
no,
Now, Mr. Sturdivant, you're aware that Eagle and DNR eventually did file a lawsuit against Boyce Hydro and Lee Moeller over natural resource damages, including mussels, right?
yes, that occurred as part of this deeper drawdown to Roanoke River.
But they didn't file that lawsuit until the level of Wixom Lake was already back to normal level, right?
Yes, that's correct.
So, Amy, let's bring up P156.
We leave this one for a second, please.
Oh, leave it up.
Never mind, never mind. I've got it on my screen. You do what you want with your screen.
Sorry, that's defendants 84, Your Honor.
Hold off on questions for a second.
Okay.
Thank you.
Thank you. Amy, P156, plaintiffs 156. So, Mr. Sturdivant, as we mentioned, there was a lawsuit filed by Eagle and DNR against Boyce Hydro and Lee Moeller. And I just want to bring your attention to the date that was filed down at the bottom. Amy, could you magnify that bottom line? Do you see
I see it.
that date's May 1st, 2020, right?
Yes,
So that's after Wixom Lake was already returned to its normal level, wasn't it?
I believe so, yes.
Amy, let's actually bring up D106. Page 356. This is Defendants Exhibit 106,
Page.
356. And Amy, could you magnify the chart? So, Mr. Sturdivant, this is from the IFT report, and it shows the level of Wixom Lake over the winter, spring of 2020. Do you see that?
Yes,
And if you look at the bottom, it lists the dates. This is just to emphasize your previous testimony. If you look at the bottom, it lists the dates of the water level of Wixom Lake. Do you see what it was on May 1st, 2020?
yes,
So Boyce Hydro had already started bringing Wixom Lake up to its normal level way back in about April 13th or so, right?
yes.
Amy, could you bring up Defendants Exhibit 132? Mr. Sturdivant, I'm going to show you another part of your declaration that you filed as your expert report in this case. Amy, could you go to page 5? So in pages 4 and 5 of your report, it identifies the questions the lawyers asked you to address. I just want to magnify that blue highlight, Amy. So this is one of the questions the lawyers asked. It said, assuming the state agencies and their agents and employees and individuals acting on their behalf developed a plan in concert with the Four Lakes Task Force to force the owner to sell the dam to the Four Lakes Task Force. So my question, Mr. Sturdivant, are there any documents you reviewed showing that Eagle and DNR developed a plan with the Four Lakes Task Force to force Boyce Hydro to sell the dam to the Four Lakes Task Force?
Not directly, no.
Is there any document that indirectly showed that Eagle and DNR developed a plan in concert with the Four Lakes Task Force to force the dam owner to sell the dam to the task force?
In my mind, just the action of transferring the ownership over to Four Lakes Task Force and require the sale in order to do that, to control water levels, was an act of forcing the dam owner to do it because they can't possibly operate the dam anymore.
Did you see any documents in your review showing that Eagle and DNR forced the dam owner to take that action?
No.
Amy, can you bring up D155? Mr. Moeller, this is an operating agreement between Boyce and Four Lakes Task Force relating to the operation of the Edenville Dam and maintenance of the Wixom Lake level. And Amy, you could kind of scroll through this. Mr. Sturdivant, do you remember reviewing this document as part of your work in this case?
Yes.
That was defendants 155.
Thank you.
Amy, could you highlight just the first three, that first top paragraph there? The very, very top. Sorry, the first three highlights. Thank you. So this describes, Mr. Sturdivant, an agreement between Boyce Hydro, the Four Lakes Task Force, and the Four Lakes Operation Corporation. Do you see that?
Yes.
Do you know the role of the Four Lakes Operation Corporation?
No.
Okay. So it's between those three parties. And Amy, could you drop all the way to the bottom? Well, first, Mr. Sturdivant, are Eagle or DNR identified as parties in this agreement?
No, not directly. I would assume they have regulatory authority over it.
Are they a party to this agreement as far as you can tell, Mr. Sturdivant?
I don't see that in writing here, no.
Amy, could you scroll to the very bottom to the signature pages, the last page, 23? So you can see there's signatures for Boyce, the Four Lakes Task Force, and the Four Lakes Operations Company. Do you see that, Mr. Sturdivant?
I do.
Okay, as far as you know, are any of those people state employees with Eagle or DNR?
No.
Okay, can you go back up to the previous page we just were at, Amy? Thank you. So go ahead and magnify the highlighted block there. So the three parties, it says, have entered into a purchase agreement in which, among other things, Boyce has agreed to sell to the Four Lakes Task Force and Four Lakes Operation Company the 4 hydroelectric projects described in the purchase agreement. Do you see that in blue, Mr. Sturdivant?
I do.
And then in the orange, it basically says that the deal involves Boyce granting, conveying, and authorizing the task force the right to access, occupy, and use the Edenville Dam, and that the task force is responsible for operating and maintaining the dam in order to manage the lake levels in accordance with Part 307. Do you see that?
Yes,
And then in the purple, it says, while the formal ownership of the Edenville Dam will not transfer to the task force until closing, Boyce and the task force desire to have an agreement in place whereby Boyce performs daily operations and maintenance of the Edenville Dam in a matter that is consistent with prudent stewardship of the dam. Do you see that, Mr. Sturdivant?
I do.
Amy, could you go to the next page? And that are consistent with the objectives of the Part 307 Lake Level Court Order. Do you see that?
Yes,
Okay. And then Amy, could you finally highlight the green area? So the purpose therefore, of this operating agreement for the Edenville Dam is to have Boyce operate and support the improvement and maintenance of the Edenville Dam and reservoir at the direction of the Four Lakes Operation Company until the closing and in order to ensure compliance with the lake level order. Do you see that, Mr. Sturdivant?
yes,
So the Four Lakes Task Force and the Four Lakes Operating Company, they're getting Boyce to agree to maintain the Edenville Dam and the reservoir at Wixom Lake consistent with the lake level order, right?
yes.
And as we looked before, there is no indication, as far as you could tell, that Eagle or DNR were parties to this agreement, right?
Nothing in here, no.
And you may have testified earlier in the day to this topic, but I believe you said that you did not see any documents in your review for this case showing that Eagle or DNR forced Boyce Hydro into negotiations with the Four Lakes Task Force, right?
Correct.
Those are all the questions I have for now, Your Honor.
Right. You're gonna have a 5-minute recess and we'll begin with continue to examine this witness. Any objections? Anything else we need to address before we take that recess? Thank you. We'll recess until until thank you. Till 2:35. So it's a little bit more. 2:35.
All right.
Thank you. Please be seated. All right, who's next? Is this a twofer?
Yes, Mr. Carlson, following.
Right. How come he's big now? He was just a little corner of a guy here earlier. All righty. Mr. Thompson,
Thank you very much, Your Honor.
you're very welcome. Please proceed when you're ready.
Oh. Mr. Sturdivant, you've shrunk again. You were full size and I looked up and you're gone.
But he's no less persuasive, so let's just move on.
I didn't mean to scare you guys there, that's all.
Mr. Sturdivant, you were asked some questions a long time ago by Mr. Gamble about a lack of anybody advising or an absence of anybody telling Eagle that lowering the water level was an appropriate mitigation step. Do you remember those questions?
Yes, I do.
Okay, I want to put some context into that. You were shown documents and reports, engineering recommendations, going back, I believe, starting in the 90s for this dam, and then carried forward into the 2000s. Some of the CSIRs, 2015 perhaps was one of the focused ones.
Thompson, can you hold on just a second?
Yeah, certainly.
Elizabeth, Mrs. Thomas brought up some folders that look like this and left them on the table in there. Would you mind please bringing them in for me? I apologize. I was too busy listening to myself tell war stories to remember what I should have done.
Do you remember all those questions, Mr. Sturdivant?
Yes.
You want to grab some water, help yourself. I know we've moved through a lot of time and I appreciate your attention. So I want to talk about what was going on in that context. Is it fair to say that when FERC is regulating a hydroelectric dam like the Edenville Dam was, that they're taking into account the status quo, that is that it's operating as a hydroelectric power generating dam?
Absolutely, yes.
And is it also fair to say then that their risk reduction measures, those mitigation measures, are all contemplated in that context?
Yes.
All right, I want to ask you then, what happens to the power generating abilities of a hydroelectric dam like the Edenville Dam if you decrease the water level?
You lose the ability to generate hydroelectricity, generate revenue, and put energy on the grid.
All right, can you explain that to us? How does that occur when you drop the water level?
The intake for the turbines on this particular dam is the same elevation as the spillway itself. So if they draw down, they start losing the operational head, or the difference in the headwater to the tailwater. And it becomes uneconomical and eventually becomes impossible for them to operate the turbine.
And is that something that FERC considers when they're regulating a hydroelectric dam and suggesting mitigation measures?
Absolutely. They are the Federal Energy Regulatory Commission.
If they lowered the water to a sufficiently decreased depth, could it eliminate the ability for the dam to generate power and money?
Yes.
It sounds to me like you're describing effectively a death sentence then?
Yes.
In all of the reports that we looked at with you, that Mr. Gamble showed you and had you agree that there was no report that ever included a recommendation to reduce the water level, can you tell us how the
maintenance decisions or the risk reduction decisions from FERC could have ever included such a recommendation to drop the water level and yet still allowed Boyce to continue to operate his business.
No,
It's
they would have,
impossible.
they would have,
right?
yeah, it would have been impossible. They would have lost the generating head.
Okay. Now, is this patience that FERC exhibited in this instance endless in your experience?
No,
You're familiar that in this case, in fact, it ended with a revocation of the Boyce license, right?
yes, I am aware.
All right. Now, before we get to that, in addition to FERC and their regulators, is it also, would I be accurate to assume then that any engineer performing a probable failure mode analysis, the type that you saw, would also be considering the context within which the dam was being used?
Yes.
And that would
Not
include
only
the
the, not
context.
only the hydroelectric generation, but the recreational pool. It's a big concern, obviously, of the residents. We saw those documents earlier.
Okay. Does it surprise you then, with all that we just covered, that in all those years from the 90s, the 2000s, the 2010s, the 2015, that there's an absence of any mitigation effort or risk reduction effort that would require the elevation to be decreased?
Not by the parties you just mentioned. There were opportunities, especially when Michigan took over the regulation of the dam and identify the fact the dam could not pass the flow it was required to pass at the half PMF, that in itself is certainly the biggest red flag, that the dam doesn't meet regulations. And the biggest one that it doesn't meet, and the most important one, is the fact that it cannot pass the design flood.
All right, so you've brought us to the point now in time where we get to Eagle's jurisdiction over the dam. Is it your understanding at that point then that there was no more hydroelectric power being generated by the Edenville Dam?
That's correct.
At that point in time, unlike FERC, did Eagle have to factor into their regulatory powers, their exercise of mitigation orders, the generating of power and electricity then?
No, that would be highly unusual.
Can you explain to us, in your opinion, based on your experience as a dam safety engineer, what the primary focus was for Eagle during their tenure as the regulatory power?
The safety of the public, and in particular, the people living downstream.
You mentioned that at the time that the 1/2 PMF test had been completed, that Eagle had jurisdiction at that point, correct?
That's correct.
You were also asked some questions about lowering the water and shown a 2013 study. You weren't shown the study, but you were shown some documents that referenced the study. Do you recall that?
I do.
Can you explain to us if the findings of that study during the full PMF standard would translate to the time period when Eagle had jurisdiction of the dam during the 1/2 PMF standard?
It gives you a pretty good idea that if it's so far off from meeting the full PMF standard, that it's very unlikely that it meets the half.
The study in 2013 that was referenced in the documents, I believe Mr. Gamble quoted to you or referenced to you statements to the effect that they considered lowering the pool, but then concluded it wouldn't make much difference. Do you recall that?
I do recall that.
Can you tell us, as a dam safety engineer, would lowering the pond produce the same expected results if you were regulating to a full PMF as opposed to a half PMF? Just help us understand that.
Lowering it to the, under the jurisdiction of a half PMF would have a much larger impact, larger positive impact, because the flood event and the volume of water associated with that event is much, much less. So a full PMF, the fact that it's not going to help during a full PMF, does not really have much bearing, if any, on what happens during the half PMF, other than give you a relationship.
And when Mr. Trumbull was in charge of the regulatory power, have you seen any evidence that he studied the lowering of the pond, lowering of the water level in the context of a 1/2 PMF event?
No.
Greg, can we pull up exhibit 413, please? Mr. Sturdivant, can you see the letter on the screen?
Yes.
You were shown this earlier, and I want to review some of the contents. This is a letter dated May 20th of 2013. It's plaintiff's exhibit 413. This is a letter from Mr. Mueller to FERC. Do you recall reviewing this during the examination?
Yes.
All right. Craig, let's go through the paragraphs. It's more highlighted than unhighlighted. The first paragraph indicates on April 24th, 2013, a conference call involving Boyce Hydropower and FERC staff was conducted for the purpose of ascertaining the status of Boyce's financial ability to commence and complete construction pertaining to the Edenville probable maximum flood spillway alterations. The construction schedule approved by FERC requires commencement in July 2013 with some initial work, and then commencement with significant dam modifications on October 2013. Were you aware in your review of the materials that Mr. Lee Mueller, on behalf of Boyce, had a conference call like this with FERC?
Yes.
Let's go down to the next paragraph. Boyce had acknowledged to FERC staff that the funds to commence the work in October 2013 are not available, and that further work, which is to take place in June 2014, is also unfunded at this time. In fact, the estimated cost of the entire project is well beyond the licensee's capacity to fund the project, given the rates for power that are paid by Consumer Energy for the Edenville project. And then he continues to describe why they're inadequate. Had you seen this prior to today?
Yes.
In your opinion, was Mr. Mueller expressing the financial relationship between his ability to generate power and maintain the dam properly?
Yes.
Let's go on to the next paragraph. Given this circumstance of insufficient earnings to support the cost of the PMF spillway alterations, Boyce is left with the requirement that it commence license surrender for the Edenville project. Mr. Sturdivant, can you talk to us about, in your experience, the concern FERC has with a hydroelectric dam owner abandoning the dam?
This is a much more common practice than revoking the license. FERC generally likes to see these plants remain up and running, but I've seen more of them surrender their license than anything else, because of the costs associated with trying to maintain a FERC license, for one, and to meet spillway capacity requirements.
In your experience, does FERC typically work for many years with dam owners to avoid a surrender situation like this?
I have seen that, yes.
In this case, I believe it was referenced as being almost 13 years where they had submitted requests, required different plans, representations from Boyce had been made, promises had been broken. Are you familiar with that long history between FERC and Boyce?
Yes,
You reviewed that in your review of the file materials?
yes, I did.
And we mentioned at some point that this all ended in a revocation. And at that point in time, when the license was revoked, what is your understanding as to the status of all these spillway alterations and repairs that were needed?
Normally under a revocation or a surrender, the owner of the dam would draw down as far as they could. Unless there was a means for someone else to take over ownership. And that would, if that's ahead of the revocation, then FERC would work with that person to see if they were going to surrender the license and just keep operating the dam itself without hydro, and then work out a plan and schedule with them. But honestly, I've never seen FERC last 13 years with a non-compliant dam.
Is that significant in your testimony earlier that you actually faulted FERC and thought they abused their regulatory power?
Absolutely part of it. And again, that should be a massive red flag when somebody else takes over
And
the
in this
regulation of this dam.
Sorry, go ahead.
No. It's another item or another consequence that the state of Michigan should have seen as, wow, what's going on here? If they're actually, FERC is revoking this license, it doesn't meet their requirements, we better make sure it meets ours. There's just so many issues.
All right, let's go down to the next paragraph and see what was going to happen with this abandonment. It reads, during the conference call, FERC's Director of Dam Safety asked Boyce to develop a plan for interim mitigation of the potential PMF event, given the fact that the Edenville Dam does not have the requisite capacity to safely pass the PMF. Do you see that?
I do.
Do you read this to mean that there were, to strike that, do you read this to signify that there was a conference between Mr. Mueller and FERC's Director of Dam Safety about this topic?
Yes.
Is that typical of your experience in a situation like this where there's a surrender being contemplated?
Yes.
And when they say interim mitigation, are you familiar with that term?
Yes.
What does that mean?
Short-term solution until the final one can be met.
And in this case, solution as to what?
As to the fact the dam cannot safely pass the inflow design flood.
It was, the letter continues, it was suggested that the only near-term option for providing any meaningful form of mitigation would be to lower the impoundment, parenthetical Wixom Lake, approximately 8 feet to the level of the spillway crests, thereby providing a safety buffer for floodwater discharge. Let's go through some of that. It would appear that there was a discussion about a safety measure, and the letter indicates that lowering the impoundment was the measure that was described as the only near-term option for meaningful mitigation. Do you see that?
I do.
Do you agree with that?
100%.
Tell us why.
It's the easiest solution to come up with until you can come up with a final one. Is you get the pressure off the dam, you increase the flood storage capacity, thereby you've increased the spillway capacity. You've reduced the likelihood that the dam will overtop or the water level will reach the point where the dam becomes unstable.
And what are the level of the spillway crests? What's that mean?
Run of river.
And in this case, we've used the elevation of 670 for the run of river. Is that what's described here as the spillway crest?
It's actually a little below that. The spillway crest is below 670.
And what is are you familiar with the phrase safety buffer?
Yes, I've seen it before. It's the same way of saying additional storage or reducing the likelihood of even higher water levels in the dam because you're not running the reservoir at full pool, which would be very dangerous, or at normal pool, which is very dangerous.
All right, let's go to the next paragraph. It reads, upon specific orders from the commission, Boyce will undertake all necessary and prudent measures to mitigate the present dam safety concerns of the commission. So correct me if I'm wrong. It sounds like this is dated back in 2013, that what was happening here was Boyce didn't have the funds to make the repairs to the dam. Is that right?
Yes.
And the repairs to the dam were for inadequate spillway capacity problems. Is that correct?
That was the biggest thing, yes.
All right. If we fast forward into 2019, is that basically the same situation that Boyce was in at that point in time?
Yes, they didn't do anything and they couldn't afford it.
And it would appear in 2013, at least as to Mr. Mueller's take on things, the only meaningful mitigation relief was to lower the impoundment to the run-of-river level, right?
That is the standard practice, yes.
And is that consistent with what your opinion is in this case that should have been done in 2019 and into 2020?
Yes.
Would you read this letter and the FERC's on discussions with Mr. Mueller to be consistent with your opinions in 2020?
Yes.
And the only difference that I can see is that in 2020, the standard was 1/2 PMF, which I believe you've testified made things all the more dangerous and a louder warning should have been issued. Is that accurate?
That is accurate, yes.
Let's take this down and go to exhibit 130, please. All right, this is plaintiff's exhibit 130, which is an email, I believe one or both of the parties have had up. It's a 4-page document. Let's go to the bottom, Craig, just to put context. And by bottom, I mean scroll down to page 4.
Page 4?
Yeah. And this is just for reference, the Bill Lang letter. We've discussed this earlier in your testimony, Mr. Sturdivant, but just to remind you, he was a citizen who had a question about the PMF levels. Do you recall that?
Yes.
All right, and let's scroll up the pages.
And I'm sorry, it's 130.
What plaintiff's 130? Yes, Your Honor. And we've now advanced to page 3. The dialogue is between the citizen, Mr. Lang, and Teresa Seidel. And there's a discussion about the spillway. Let's zoom in on the middle section, Craig. The top highlight, please. Ms. Seidel, just to remind Mario Fusco's supervisor, who in turn was Luke Trumbull's supervisor, Mr. Sturdivant. November 12th of 2019, she briefly responds to Mr. Lang and states, Boyce's engineer had submitted some analysis that indicated that the dam did meet state requirements. Eagle concluded that the analysis were incomplete, flawed. The consultant is gathering information needed to do a better analysis. Let's scroll up then to the top. Yes, thank you. The second page just contains some more back and forth, and eventually this letter finds its way to Luke Trumbull, and he takes on the task of responding or providing the site with a response to the concerned citizens' inquiry, and says, sure, I'll take a stab at it. And then this is his proposed answer. In the first paragraph, he talks about taking over the dam and what the came-out analysis was. He's done some calculations and states in the last sentence. So it was very clear that the dam did not meet the first spillway capacity requirements, which ultimately led to the revocation of the license by FERC and jurisdiction over the dam to revert to the state under Part 315. Next paragraph.
You have a question? Because you don't need to read evidence to me.
Yeah, I'm sorry. I'm just trying to put it in context. Let me get right to the,
Thank you. Don't mean to be rude.
nope,
Done.
appreciate it. And I'm trying to move through this as well for Mr. Sturdivant's timing. What?
Mr. Sturtevant's like, oh my, I'm gonna be with these guys again tomorrow.
Briefly summarizing, you've had a chance to review this. This is where Mr. Trumbull does the math and talks about the different studies and the 1/2 PMF. Let's go to the next paragraph. Direct your attention to the last couple lines where he says Spicer indicated that the capacity of the dam was previously overestimated and that the true capacity in its current condition does not meet the state requirement to safely pass the 1/2 PMF. My question to you, Mr. Sturtevant, is despite all the different studies that you were shown that did not indicate any problems with the dam, at this point in time in the record that you see before you, is it apparent that Mr. Trumbull has in fact appreciated the failure of the dam to comply with the Michigan 1/2 PMF standard?
Yes, it does.
And this, Craig, is dated, this exchange November 13 of 2019. Could you just bring up the date quickly? Thank you. In any of your review of the file, Mr. Sturtevant, did you find any evidence that Mr. Trumbull was confused or mistaken or in any way needed someone to alert him that the dam suffered a spillway deficiency and inadequacy?
No.
You were asked some questions about Spicer Group and what to make of their recommendations. Do you recall those questions?
I do.
Could you speak to us briefly about the difference between a hired engineering consultant firm like Spicer, who's working for a private party, and Eagle engineer, Mr. Luke Trumbull, in terms of making safety decisions relative to Part 315?
It's very black and white. Spicer doesn't have any regulatory authority, and I have not seen where any consultant in the hundreds and hundreds of dams I've worked with that comes out and says, well, we're recommending that the regulatory authority take over the decision-making process here. We're giving you the facts that the dam does not meet spillway capacity. Now it's up to the regulator to decide what to do with it and how to proceed. And keeping it quiet, not putting the information forth in any kind of hearing for a permit or an order, or just making people aware of it is unusual.
During all your years as a dam safety engineer, when you got reports from a hired private engineering company working for one of the entities you're regulating, how would you account for, their economic interest or perhaps just normal bias?
You have to cut through that, and you have to look at what are the facts. What characteristics of the dam make this dam unsafe? Is it unsafe? Does it meet the requirements, and can we let it move forward with holding a normal pool, knowing that the dam does not meet requirements, and we've just reduced its ability to do so? The conclusions have to be drawn by the regulator. The information is all there for a regulator to use in developing those conclusions.
Is it fair to say then that ultimately that regulator, in this instance, Luke Trumbull, was the one responsible for implementing 31519 as well?
Yes.
And tell us again about a situation where someone like Mr. Trumbull was under pressure, whether it be from public or environmental concerns, and ultimately their obligation to protect public safety. How do they balance those different forces in your experience?
You have to consider all those underlying factors, but you have to consider public safety, number one. What is who's at risk, and are we willing to put those people at risk for any other purpose other than making the dam compliant with the intent of the code that's supposed to make the dam safer?
All right, let's end with some discussion about what you just spoke to and ultimately what happened in this case. First of all, did any of Mr. Gamble's questions change any of the opinions that you testified to last week?
No.
Did any of the exhibits that he referenced or testimony that he showed you cause you to change your opinions?
No.
Does that include the safety related, the opinions you gave us to the safety related problems and operating the dam at normal levels being dangerous?
Yes.
All right, let me ask you to focus on the January of 2020 time period and moving forward, okay?
Yes.
Could you tell us what the hydraulic problems were at that point in time that were documented in the record and that Mr. Trumbull had knowledge of?
I'm assuming you're referring to the lack of spillway capacity to meet the state requirements, and that due to the gates not being fully operable to the full opening, and the likelihood that under a flood event or under high water that the gates would transition from an open flow or a spillway flow into an orifice flow situation and reduce the spillway capacity further.
And could you tell us what the structural problems were that exist?
Just a second, let me just catch up on notes. Go ahead.
Were there hydrologic problems that you noted existed as of that date and that were in the record documented that Mr. Trumbull was aware of?
I think the biggest one was that the hydrology showed that if a flood event did occur, that the dam can't pass it.
That's the 1/2 PMF test that was confirmed.
That's correct. Yeah, yes, that's correct.
And lastly, sir, can you identify for us the structural problems with the dam itself that existed on that date that you believe were documented in the record and that Mr. Trumbull knew of?
We'll start to the right and move to the left, but the concrete in the spillways was in need of repair. The gates themselves and the operation system needed to be changed.
Hold on. Hold on one second, Mr. Sturtevant.
Going too fast, sorry.
Yep. What was the second one?
That the spillway gates themselves needed work. Not only to make them operable, but container gates at that age are going to need some maintenance. The biggest concerns were in the left embankment that failed, and that's the historic documents that apparently were made available to the Four Lakes Task Force. I saw a reference to that, and so they were available either through the owner or the state actually had them. And I know I did not see documentation of that, but I did. This dam was not regulated by FERC when it was built. So the state would have the original documentation involved with construction and approval and construction inspection. So those records were there. Seemed pretty easy for others to find it. And then in those documents, it is just blatantly obvious how poor the construction techniques and how poor the soils were in that left embankment, and the lack of, there's a whole section on that embankment that did not have the same drainage system built into the embankment that the rest of it did. I couldn't find any justification for why that was, but it certainly would throw up a red flag that maybe we should take a closer look at that. Why weren't those there? And the past geotechnical engineering reports indicated that the 3 borings that were taken out of that embankment showed very loosely compacted granular material, highly susceptible to seepage. Yet they didn't have the data really necessary to do a detailed stability analysis, and they didn't do it. And the fact that all the reports identify stability analyses on the earthen embankments after the fact that the spillway, those embankments received what's called a weighted filter buttress, which is a filter with a bunch of heavy material on the outside of it. I know that's a very rudimentary explanation, but for lack of a better thing, it provides embankment stability, and it also can collect any seepage that's coming through the dam in that location and safely discharge it. None of that was done on the left embankment, and that should have been a huge red flag to anyone just walking it that has experience in dam safety.
Mr. Sturtevant, with the hydraulic, the hydrologic, and the structural problems you identified, is it your opinion that all those problems posed a danger to the dam's stability and ability to pass water during a flooding event?
Yes.
Did anything Mr. Gamble asked you or an exhibit he showed you cause you to change your opinion as to that fact?
No.
Mr. Sturtevant, given the records and the testimony you've reviewed, have you found one valid reason justifying raising the Wixom Lake levels in April of 2020?
No.
Sir, in your own words, can you describe for the court the degree to which that act was an abuse of dam safety regulatory power in this case?
It was the perfect opportunity to do otherwise. You had the authority that wasn't used, and you also just allowed the dam to further be in that category of an inadequate spillway. So you further reduce the spillway capacity.
Thank you very much, Mr. Sturdivant. That's all the questions I have.
May I proceed, Mr. Carlson?
Mr. Sturdivant, good afternoon again.
Good afternoon.
Good to see you. Can you hear me?
Yes, I can.
Okay. I want to take you back to a portion of Mr. Gamble's cross-examination. And just to orient you to the subject matter, do you recall him talking about how the reason why Boyce would have been looking to raise water levels was because they had a private arm's length agreement with the Four Lakes Task Force, and they were being paid by the month to keep that water level raised up? Do you recall that?
Yes.
And do you recall the suggestion by Mr. Gamble in his cross-examination that the other reason why Boyce would be looking to raise the water level up is because that's what the circuit court 307 lake level order provided for them to do? Do you recall that?
Yes.
And do you recall Mr. Gamble drawing your attention in particular to the fact that the Department of Attorney General or Office of Attorney General did not sue Boyce for lowering water until after it had started to refill Wixom Lake under the authority granted by that April 2020 permit? Do you recall that emphasis on when the lawsuit was filed?
Yes.
Craig, if you could bring up Exhibit 135, please. I want to draw your attention, Mr. Sturdivant, to some other documents in the file and in this case related to the Attorney General's office and this idea of litigation against Boyce. Exhibit 135, which you have in front of you, is an email from Nathan Gamble to Lawrence Kogan and Joseph Colian dated 12/12/2019, subject cease Wixom Lake drawdown. Do you see what I'm referring to?
Yes.
And the attachment to this email is a document called Edenville Enforcement Notice.pdf. Craig, if you scroll down to page 2 of the exhibit, please. Mr. Sturdivant, do you see the, yeah.
Yes.
Yeah, hold on. Waiting for me. Go ahead.
Do you see the attachment to Mr. Gamble's December 12th email, which is a letter from the Department of Environment, Great Lakes and Energy to Lee Mueller dated December 12th, 2019?
Yes.
And the very first paragraph of this email, if you want to take a look at it, Mr. Sturdivant, it mentions Part 307 of the state statute. You see that?
Yes.
And it mentions an unauthorized activity, includes the drawdown of Wixom Lake below the elevation of 672.8 NGVD 29 allowed by the Part 307 lake level order?
Yes,
And just to be clear, this is not the Gladwin or the Midland County Circuit Court or the county commissioners of Gladwin and Midland County reminding Boyce that they're not in compliance with the 307 lake level order, is it?
that's correct. This is Eagle Water Resources Division.
And this isn't Dave Kepler or anyone at the Four Lakes Task Force nudging Mr. Mueller to tell him, hey, remember, we've got a contract where you're being paid to keep the lake level order up. This is not that kind of correspondence either. Would you agree?
Yes,
Craig, if you go down to the third paragraph of the letter, please. Actually, third and fourth paragraph. The third paragraph begins, quote, Eagle would like to provide you with an opportunity to comply with the legal requirements of Part 301, Part 307, and Part 303 by immediately ceasing active drawdown of Wixom Lake and coming into compliance with the Part 307 lake level order. Do you see that?
I do.
And is this consistent with your understanding that Eagle, as the entity responsible for enforcing the Dam Safety Act, Part 301?
No, I was actually a little bit surprised that they took this action under 307 because it's specifically a court's decision.
And so you're surprised by them getting involved in this and providing Boyce with an opportunity to comply with Part 307.
Yes,
And if you look at this last paragraph, it says, quote, if you do not immediately cease the drawdown and return Wixom Lake to the level authorized under the Part 307 order, Eagle may take escalated enforcement action against Boyce Hydro and others who are collaborating with Boyce on the drawdown. That could include referral of this case to the Department of Natural Resources Environmental Investigations Section and the Department of Attorney General. Do you see that?
I do.
Is that consistent with your understanding of what Eagle was actually doing in this case?
Yes, it is. This is, to me, a direct threat.
Craig, if you go back up to the email, the first page of the exhibit, please. Drawing your attention again to the email from Mr. Gamble that attached this letter. Do you see where Mr. Gamble writes, quote, as I indicated in our calls today, the quickest way to de-escalate this situation is for Boyce to immediately stop the drawdown and return the lake to the winter drawdown level authorized by the Part 307 order. That's also the only way Boyce can mitigate damages at this point, as far as I can tell. Do you see that, Mr. Sturdivant?
I do.
Is that consistent with your factual understanding of what Eagle and the Attorney General's office were doing in relation to Boyce's decisions about raising and lowering water levels?
It is.
Craig, if you go to Exhibit 142, please.
I'm sorry, what number?
142,
Thank you. That's plaintiff's 142.
yes. Mr. Sturdivant, drawing your attention to plaintiff's exhibit 142. This is an email dated January 21, 2020, which is about 5 weeks after the previous message from Mr. Gamble to the attorneys for the task force and for Boyce. And do you see where in this email, Mr. Gamble writes, quote,
I promised in our call last month that I would give you the courtesy of a heads up if the state planned to file a civil action over Wixom Lake drawdown in 2018 and the current 2019 drawdown. The state has planned to move forward with such an action. It will be on behalf of the Attorney General, the Department of Natural Resources, and the Department of Environment, Great Lakes and Energy, and it will be against the Boyce entities and their members, including the various Boyce trusts, Lee Mueller, Michelle Mueller, and Stephen Holberg. Do you see that?
Yes,
Is it your understanding, based on your familiarity with the records in this case, that as of January 21, 2020, the water was still drawn down approximately 8 feet from normal level, which Boyce had done without authorization?
yes,
And in this email, in the next paragraph, Mr. Gamble is telling the attorneys for Boyce and the Four Lakes Task Force that the state alleges that those drawdowns killed millions of freshwater mussels, among other natural resource damages. Do you see that?
yes,
And he tells them that when they file this lawsuit, they're going to seek damages in order to restore the mussel populations and otherwise repair the environmental harms the drawdowns have caused, and an injunction against any future unauthorized drawdowns. You see that?
yes, I do.
In the context of dam, state activities towards a regulated dam, do you also read this email message as a threat?
Absolutely. They're moving to sue an entity that doesn't have money to begin with because they're not generating, and gives them little choice but to comply.
Mr. Gamble concludes this email in the last paragraph, Craig. By writing, quote, "The Four Lakes entities are not named as defendants at this time, but I've copied their attorneys because they obviously have an interest in how this case proceeds." Do you see that?
Yes,
Now, is it your understanding, based on your review of this matter, that the Four Lakes Task Force was attempting to close on a purchase of these dams from Boyce at this time?
that was my understanding.
And based on your experience in the world of dam safety and regulation, would a purchaser of those assets want the seller to be embroiled in litigation with the state of Michigan, where the state of Michigan is looking for an injunction on water levels and damages, maybe hundreds of millions of dollars before they purchase?
I can't see that they would.
And have you seen the emails? I think Mr. Gamble drew your attention to emails where Mr. Kepler from the Four Lakes Task Force was telling Mr. Mueller time was of the essence to get the water raised back up in April of 2020.
Yes, I do recall that.
And in those emails, was Mr. Kepler also saying to Mr. Mueller, it's bad for this purchase agreement if you drag us into litigation with the state of Michigan?
Yes,
That would certainly put some urgency behind their desire to avoid litigation by getting those water levels back up, wouldn't it?
yes, it would.
Craig, if you can go to Defense Exhibit 106, please. Page 138. Mr. Sturdivant, calling your attention to Defense Exhibit 106, this is the IFT report. And in the bottom half of paragraph 138, under geotechnical evaluations for Edenville Dam, do you see that?
Not yet.
Oh, Craig, I'm sorry. It's going to be page 162 of the PDF, or something like that. It's going to be 139, 138 of the report.
That would explain why I didn't see it.
Yeah, that does it. 138.
It should be 162 of 502 of the exhibit.
That's correct.
And where did you want me to start reading? Oh, on the bottom? Okay.
Yeah, where it says geotechnical evaluations for Edenville Dam. Do you see this sentence which begins, the IFT did not find evidence that a comprehensive geotechnical review of the Edenville Dam embankments was ever completed? Do you see that?
Yes,
And I think that you testified under cross-examination from Mr. Gamble that geotechnical review is a term that is basically synonymous with embankment stability, correct?
that is a result of a geotechnical analysis. Yes,
A stability analysis.
yes,
And you agree with the IFT's finding of no evidence that a comprehensive geotechnical review of the Edenville Dam was ever completed?
I totally agree. That's what I was getting at. What there's no detailed analysis, especially on the portion of the dam that failed.
And would you agree that the IFT continues in this report to make an observation and a finding, which I believe is consistent with your own, that the limited stability analyses that were completed were on the sections of the dam, specifically the right embankment, which was not the section of the Edenville Dam that failed? Is that consistent with your understanding as well?
Yes,
Yeah, hold on a sec. Mr. Wanda, do you want to talk to Mr. Carlson?
I was gonna give a piece of paper for people, but you know. That's, yeah. Okay, yeah. Sorry.
Nope, I specifically said lawyers could pass notes to one another. We're unlike how we were all treated in junior high, that's allowed in this case. Number of lawyers, so we have finite number of lawyers doing the actual exam. So please proceed.
At the next paragraph, Mr. Sturdivant, it indicates that the IFT did complete static stability analyses for the embankment section that failed by simply using the same cross-section characteristics scaled to the geometry of the failure section and soil parameters previously used in the stability analyses for the taller sections of the Tobacco and Edenville embankments. Are you familiar with that aspect of the IFT's report?
I am. That's pretty forgiving because the soils were worse in the embankment they were looking at.
So if anything, the soils in the left embankment that failed were actually worse.
Correct.
If you look on the next page, Craig. Mr. Sturdivant, do you agree with the IFT's conclusion that had this analysis been completed by the consultants, it would likely have led to either further investigation of that section or directly to modification of that section?
100%.
And do you share what the IFT says? It is confident that further investigation would have confirmed the low factors of safety?
Yes.
And do you
I
share
think lower. I would be willing to bet lower.
that further stability analysis of the left embankment would have shown an even lower factor of safety than what they were assuming?
Yes.
Do you agree with their assessment that modification of the section to improve the factors of safety, such as slope flattening or a berm, would have reduced the static stress ratios on the dam, which likely would have prevented the failure that occurred on May 19, 2020?
Yes.
And the stability analysis, the IFT says here, to be clear, it might not have predicted that static liquefaction would be the failure mechanism. Do you agree with that?
Yes.
But once it's identified through a stability analysis, the necessary modifications would have prevented the dam failure.
I agree.
Craig, if you look, oh, sorry. The third paragraph on this page, Mr. Sturdivant concludes, however, in circumstances like those with the Edenville Dam, the need to resolve uncertainties is high. and protocols can be used to limit the risks of explorations. Do you agree that when it comes to dam safety, in situations like we had with the Edenville Dam, the need to resolve uncertainties was high?
Yes.
Exhibit 214, please, Craig. Craig, if you go to page 2 of exhibit 214. Mr. Sturdivant, drawing your attention, page 2. Page 2 of exhibit 214 is an email in the middle part of the page from Luke Trumbull to the members of the IFT team dated September 1, 2021. Do you see what I'm referring to, Mr. Sturdivant?
I do.
And as part of your review in this case, did you look at some of the things that Mr. Trumbull told the IFT about the facts and circumstances of Eagle's regulation and the failure of the Edenville Dam?
Yes.
Craig, if you go to page 5 of the PDF, please. Yes. And if you could please highlight the bullet that says February 7, 2020. Mr. Sturdivant, in the bullet for February 7, 2020, Mr. Trumbull writes to the IFT team, quote, on February 7, 2020, Eagle received an email from FLTF's consultant indicating that the Part 315 Dam Safety Inspection Report would be submitted at the end of March and would include conclusions and recommendations, re-spillway capacity, as well as ongoing geotechnical investigations and other due diligence FLTF was performing as part of acquiring the dams. Do you see that?
Yes.
Is that consistent with your understanding that at this point in the timeline, Eagle knew that Spicer Group was going to be providing it with a Part 315 dam safety inspection report?
Yes.
And is that consistent with your understanding that Mr. Trumbull from Eagle Dam Safety was expecting to receive that dam safety inspection report at the end of March 2020?
Yes.
Later in that email on page 6, Craig, last full bullet paragraph. Yeah, it says, as for the embankment stability issues. Mr. Trumbull writes to the IFT here, as for the embankment stability issues, Eagle was largely uninvolved / unaware of the embankment stability concerns other than was publicly available on e-library or in news media during the several years that Boyce was making embankment and drainage upgrades. Eagle began to better understand the issues that brought about those repairs as we received additional documents from FERC via CEII-FOIA request. It was not until after the failure of the eastern embankment that Eagle questioned why similar embankment stability drainage improvements were not made or even planned, as it would appear, for the section of the embankment that failed, even though it was of similar construction to those sections that did require improvements in previous years. So absent inspection
Hold on.
reports.
I want to see two orders from both sides over here. Just had a brief meeting with the lawyers regarding schedule, so. All right, please continue, Mr. Carson.
Mr. Sturdivant, do you see here where Mr. Trumbull concludes, absent inspection reports and or stability analyses indicating problems with the east embankment at the time, Eagle was more focused on the spillway capacity issues and didn't focus on embankment stability until after the failure had occurred. Is that consistent with your understanding of the records in this case?
Yes.
Craig, if you go to exhibit 104, please, plaintiff's 104. It'll be on page 8.
104. Mr. Carlson, thank you.
Yes. Drawing your attention to the second paragraph, which is just a single line here, Mr. Sturdivant, on page 8 of exhibit 104. This is the Spicer Part 315 Dam Safety Inspection Report. What does Spicer recommend?
An embankment stability analysis.
Spicer recommends an embankment stability analysis.
Yes.
Is there any reason why in April of 2020, Eagle had to authorize the refill of Wixom Lake before having the benefit of receiving this Part 315 inspection and in the recommendations included in it?
No.
That's all I have, Your Honor. Pass the witness.
Thank you. Plaintiffs, we good?
We're good.
All right. Mr. Campbell, you may proceed.
Your Honor.
You're welcome.
Mr. Sturdivant,
Fine.
oh.
Who needs something?
We reject them doing this. Your Honor, if it's not a joint witness indicated that you correct cross.
They said on experts you could do,
All
the experts was the asterisk to my direct cross redirect on experts. If I didn't say it, I apologize. I'm
Okay. You invited
72% like sure that I said on experts, you get to do recross and redirect and redirect. So yeah, whoever calls the expert gets asked the last questions if they choose to. So anyway, let's.
Thank you, Your Honor. Amy, could you bring a D59, Defendant's Exhibit 59? Mr. Sturdivant, do you recognize this press release from earlier today?
Yes.
This is dated,
The press release is not from January 20th, 2026. It's from earlier exam, right?
right, the exam from when I,
Somebody, okay. Thank
no,
you.
from when I showed you this.
I got it.
Okay, thank you.
Your trial judge was about to have a heart attack.
All right. Mr. Sturdivant, this is dated September 2019, is that correct?
Yes.
And that last highlighted paragraph, Amy, if you could magnify it, the Four Lakes Task Force, in referring to its application to lower Wixom Lake over the winter, they explain that that will not interfere with summer lake levels, right?
That's what it says. Yes.
So as of September 2019, the Four Lakes Task Force's plan was to refill Wixom Lake in the spring of 2020. Isn't that right?
Yes.
You were shown emails from December by Mr. Thompson. He showed you emails from, or excuse me, Mr. Carlson, from December of 2019 and January of 2020 about mitigating damages related to the winter drawdown that were being caused to mussel populations. Do you remember those emails that he showed you,
Yes.
Mr. Stewart?
Yes,
And those were issued after this press release, weren't they, Mr. Sturdivant?
yes,
Four Lakes Task Force and Boyce Hydro, they already had a plan to return Wixom Lake to the normal level in the spring of 2020, months before receiving either of those emails. Isn't that right?
yes.
And the enforcement notice in December 2019, you testified that that had no impact whatsoever on the level of Wixom Lake in the spring of 2020, didn't it?
It could have if the water level was held down that 8 feet. That's what I was trying to get at.
But the enforcement notice in December 2019 that asked Boyce Hydro to return Wixom Lake to its normal winter level where it would have been, Boyce Hydro did not follow that enforcement notice, did it?
Not to my knowledge.
They already had a plan announced 2 months prior to return Wixom Lake to its spring level in the spring of 2020. Isn't that right?
Yes, keeping it at 8-foot drawdown until then.
And I believe that you testified to Mr. Carlson's questions that you thought that the Four Lakes Task Force and Boyce Hydro were threatened into returning Wixom Lake to its normal spring level in the spring of 2020. Is that right?
Yes,
Who did you talk to at the Four Lakes Task Force that gave you that impression?
no one.
What document from the Four Lakes Task Force did you review that said that they were threatened into implementing the plan announced in this press release by the threat of litigation from Eagle and DNR?
Can you rephrase that?
Yes.
Thank
What
you.
document did you review from the Four Lakes Task Force in which the Four Lakes Task Force explained that the reason they were returning Wixom Lake to the normal summer level in the spring of 2020 is because Eagle and DNR threatened them with mussel litigation?
I believe I was basing that on an email from you.
I understand, Mr. Sturdivant. What I'm asking you is what document you reviewed from the Four Lakes Task Force, authored by someone from the Four Lakes Task Force, in which they said that they were implementing this plan to return Wixom Lake to its normal summer level in the spring of 2020 because they were threatened by mussel litigation.
I think that came after. So I did not see one.
Okay, that came after. What document did you see? Which one?
I believe it was yours that threatened them with
Do you
the,
think that I work for the Four Lakes Task Force, Mr. Sturdivant?
no, you don't.
Okay, what I'm asking you is what document you reviewed for the Four Lakes Task Force, or what document did you see authored by someone from the Four Lakes Task Force in which they said they were carrying out their plan to return Wixom Lake to the normal summer level in the spring of 2020 because they were threatened by mussel litigation?
I did not see such a letter.
So you didn't talk to anyone at the Four Lakes Task Force on this issue, right?
No, I did not.
You didn't see any documents from the Four Lakes Task Force saying that, right?
I did not.
You're just guessing, Mr. Sturdivant, isn't that right?
Basing it on what I read, it may not have come from the Four Lakes Task Force, but they had to know it existed.
And those emails you read, they were issued months after this press release, weren't they?
Yes,
What about Boyce Hydro? What documents authored by someone at Boyce Hydro did you review in which Boyce Hydro said that they were returning Wixom Lake to its normal summer level in the spring of 2020 because of threats of mussel litigation by Eagle or DNR.
I did not see any.
And you didn't talk to anyone at Boise Hydro on that issue, did you?
No,
You didn't talk to anyone at Boise Hydro at all, right?
I did not.
Mr. Sturtevant, is it your testimony that the Federal Energy Regulatory Commission elevates the generation of electricity over public safety?
I have seen that in my experience.
Is it your opinion that that's what the Federal Energy Regulatory Commission did in this circumstance with the Edenville Dam, that they elevated electricity generation over public safety?
I think that did occur for a while until they realized that Boyce wasn't going to do anything or couldn't afford to do anything, and then issued the revocation order.
So it's your testimony that the Federal Energy Regulatory Commission risked public safety for 20 years in this case for the sake of continuing to allow a private company to make money selling electricity. Is that what you're saying?
In my opinion, yes.
In 2013, Boise Hydro raised the potential of surrendering its license for the Edenville Dam. Do you remember seeing that letter from Mr. Thompson?
I do.
Did Boise Hydro ever actually do that?
No,
As far as you're aware, did they ever actually submit a surrender application to
I
surrender?
did not
the
see
license?
one.
Okay. And in that letter that Mr. Thompson showed you from 2013, he highlighted language from Mr. Mueller stating that he thought that lowering Wixom Lake would be a potential solution to reduce the risk caused by the dam's lack of spillway capacity. Do you remember that?
Yes,
Boise Hydro never actually implemented that solution, did they?
not to my knowledge.
And I think you testified previously that you did not actually see any documents that the state had access to prior to the dam failure showing the historic construction process for the Edenville Dam, right?
That's correct.
You're just assuming that the state had that information, right?
Yes, in my experience, the state would have had that information or had access to it.
You just didn't see it here, right?
I did not. I
And
only saw it as a appendix to the IFT.
the IFT report was issued 2 years after the dam failed, right?
Yep. Yes,
And you testified in response to Mr. Thompson's questions that you thought that the Edenville Dam had to be approved by the state of Michigan in order to be built in 1924. Was that your testimony?
I'm not sure if I said approved, but the state would have overseen it. There would not have been a formal dam safety program back then, but certainly there would have been other concerns.
What's the basis for your conclusion that the state oversaw the construction of the Edenville Dam in 1924?
Hundreds of documented cases that I've dealt with historical documents and historical procedures, even though there may not have been a formal dam safety program, the state would have been involved.
Is there any document you have seen confirming that the state of Michigan oversaw the construction of the Edenville Dam?
I don't remember who signed off on the construction documents and on the inspections, whether or what level of government that was at.
Are you aware that Part 315 did not become law until the year 1990?
Yes, yes.
Amy, could you please bring up Defendant's Exhibit 106? Could you go to page 163? And could you highlight the first full paragraph, starting the example? Thank you. Mr. Sturdivant, the IFT report refers to two common practices in the embankment dam stability analysis. Do you see that?
Yes,
Those were common, it was a common practice at the time the stability analysis were done for the Edenville Dam to focus on the maximum height section of the embankment, right? Not the entire embankment.
it says here that is not always the most critical, so it's a problem.
That's fair enough, but at the time the embankment stability analysis were done, it was a common practice to focus on the maximum height section of the embankment. Isn't that right?
At that time, it was, in my experience, it's common to take each one of the individual sections of the dam and analyze them separately, whether it's embankments, concrete, powerhouse, spillways. Each one has to be looked at separately because they're all different.
The IFT, though, is saying that a common practice at the time was to just focus on the maximum height section of the embankment, right?
I do see they said that. That has not been my experience.
Well, and the IFT is calling that a problem, but at the time, that was the common practice, at least according to the IFT, right?
According to this statement, yes, but again, it's not my experience.
Finally, Mr. Carlson showed you an email from Mr. Trumbull in which he indicated that no stability analysis at the time had called attention or identified any problems with the left embankment. Do you remember seeing that email?
I do.
That's consistent with the IFT's conclusion, isn't it? That none of the engineering reports at the time prior to the dam failure identified any stability concerns that had not already been resolved. Isn't that right?
Yes. I don't think that's what the IFT said either. It was the fact that they didn't include all the different sections.
Okay, let's go in that case to PDF or page 16. Oh, excuse me. One five three. Actually, what? Yeah, that's the one. Could you magnify that, please? Yeah, magnify the highlighted section. Mr. Sturdivant, the IFT did say that last sentence starting with "in the case of the Edenville Dam," it said that none of those engineering reports had identified any significant embankment stability concerns, which had not already been addressed by embankment overlays and drain modifications, right?
Yeah, that's correct. And again, they did not look at the dam, part of the dam that wasn't already fixed.
You mean the engineering reports?
That's correct.
Okay, but at the time, regardless of what they looked at, none of those reports flagged the left embankment as something that needed attention, that its
They did not.
stability was unstable, right?
They did not.
All right, that's all, Your Honor. Thank you.
Redirect both sides. And let me just make sure everybody understands. You can take as much time as you need. And if we need our witness to come back tomorrow, that is not a problem for the court in any way, shape, or form. And if it's going to be a little bit longer, we'll ask Mr. Sturdivant if he can stay with us. If he can't, then we have no problem. We are going to give you the time you need to examine your witness.
I do understand that,
The
Your Honor.
defense does not get to ask any more questions.
I understand that, Your Honor. But may I ask Mr. Sturdivant, do you have 3 more minutes?
3 you have, sir.
3 I have. Thank you very much. I only have one question for you, Mr. Sturdivant. The defense has shown you a variety of exhibits about different people's plans for the water level Four Lakes Task Force, Boyce's, a variety of people as to what level they wanted to bring that lake to. But on May 19th of 2020, who, in your opinion, authorized the water level raised to the level it was at when this dam failed?
Eagle.
Thank you.
And same statements to you, sir. If you
Thank you.
need, if you need 6 hours, we're gonna give you 6 hours.
Appreciate it,
So
Judge.
You just
Yeah.
need whatever you and your clients require, that's what you're gonna get.
Yeah. Craig, exhibit 152, please, latest 152. Mr. Sertivant, I'm showing you exhibit 152, which was shown to you on cross by Mr. Gamble. This is an email from Dave Kepler at the Four Lakes Task Force to Lee Mueller, Michelle Mueller, and the attorney for the Four Lakes Task Force on April 8th, 2020. Is it your understanding that Mr. Kepler was asking Mr. Mueller to sign the permit that Eagle would issue to authorize the refill activities of Wixom Lake?
Yes.
And what does Mr. Kepler say to Mr. Mueller here in the underlined portion of the first paragraph?
Oh, up at the top, the consequences of you. And
Yeah, that's it.
okay.
He says to
That's
Mr.
saying
Mueller,
it's likely if you do that, you're going to end up in trouble with Eagle. That's how I read it.
the words he uses are the consequences of you and Eagle getting in a dispute that leads to impairment of our agreement is extremely high, as I explained yesterday. That's what he told him.
Yes.
And then in the next full paragraph where it's highlighted, he says to Mr. Mueller, this lake fill and a Boyce Eagle dispute cannot become an impediment, end quote. Is that what he says?
He does.
And Craig, if you go to the third page of the exhibit, please. In the second paragraph of his letter dated April 8th to Mr. Mueller, Mr. Kepler wrote, while acknowledging your concerns, we believe that time is of the essence to raise the Wixom Lake level to its normal summer level. Is that right?
Yes.
And he wasn't saying to Mr. Mueller, hey, we can go ahead and do this on our own. We've got ourselves a contract. I've already put it in a press release and it's part of a 307 order. He's trying to get Mr. Mueller to sign off on the authorization that Eagle will issue. Is that your understanding?
Yes.
Mr. Sturdivant, do you agree with the proposition that a change or that a chain is only as strong as its weakest link?
Yes.
And does that apply to dam safety, that a dam is only as safe as its weakest section?
100%.
And how does that relate to your opinion in this case that Eagle should not have authorized the refill of Wixom Lake until such time as it could resolve any safety issues before doing so?
The weakest link being the lack of spillway capacity and the most dangerous link when it comes to that.
Mr. Sturdivant, is it your understanding, having operated in the world of dam safety for some time, that if two parties get together and privately agree to do something that's dangerous, and then they're approached by dam safety regulators to say, you can't do that, it's dangerous, can they go, well, we have an agreement, so we can do it? Is that
No,
allowed them to do it?
no. That agreement means absolutely nothing when it comes to administration of the dam safety rules.
So what if they say, we have an agreement And we've issued a press release saying that we're going to do it. Does that keep them out of the regulator's way if the regulator says it's not safe? I don't care.
Absolutely not. No.
Thank you, Mr. Sturman.
Anything else from plans? All right. May Mr. Sturtevant be excused from further testimony at this juncture.
Thank you for the accommodations.
Any objection?
No.
All right, Mr. Sturtevant, thank you. It's been a privilege to serve on a case where you've been a witness multiple times. Thank you. Your testimony has been informative for the court, and I'm very appreciative of you and all the lawyers of all the work you did getting ready for the case and being with us a few times, both in person and electronically. So I hope you have a pleasant remaining portion of the day. Thank you.
Thank you very much.
Mr. Sturtevant is excused. At the time is 6 minutes after 4. I did ask for a sidebar that lasted just a minute or two. Mr. Thompson, Mr. Carlson, Mr. Gamble, and Mr. Poole came by, and the reason I asked for it is I wanted to, our Mr. Sturtevant, who's just completed his duties in this case as a subpoenaed witness, I assume he was as a witness, had indicated he needed to leave at 4. I was looking at the clock and I was thinking, I'm very appreciative of Mr. Sturtevant's wisdom and his sharing his testimony with us. But candidly, as a trial judge, I wanted to get his testimony completed today if it was possible. And the reason I asked for the sidebar was to get a read from Mr. Thompson, Mr. Carlson, and in the end, Mr. Gamble of their estimate. And I said, listen, if we're close to 4, we need to get them to stay, and I'll give you time, and you can call them, text them, and both Mr. Thompson and Mr. Carlson said they were sure that it would not be a problem. And then when we continued, Mr. Wan interposed a concern / objection to the redirect. I'm sorry, the recross, and indicating he didn't believe that the court's case management order provided for that. First, let's address the sidebar, memorialize that, then I'll address Mr. Wan's objection. Anything else on the sidebar that we had during Mr. Sturtevant's last session of testimony with us?
No, Your Honor, our variation is not impeded.
No, yeah, well, thank you. I appreciate that.
No, Your Honor, it's accurate.
Mr. Gamble. Okay. Mr. Wan interposed a concern / objection that I was letting recross take place, and he felt that that was violative of my court order. I did pull the order, and I think I should have been more clear. And so I don't think Mr. Wan's concern is without basis. I will tell you, it has always been my intention in this case that on expert witnesses, everybody gets, they're just too important for me. And I should have made it more clear in my order issued January 5th or thereabouts of 2026. I said, any party who is endorsed by both witnesses, we would do direct, cross, redirect, recross, redirect. And I didn't say specifically experts. And that was my mistake. And I apologize for that. I think I've already allowed that in the case, but I am truly sorry I didn't say that. In the paragraph, the final paragraph of that order, I did say the court reserves the right to amend this order. And so I'm orally, I know courts speak through their orders written, but I'm speaking orally and modifying it to the extent I need to. And again, Mr. Wan, thank you for raising that. I wish I would have been more diligent in my duties, but I wasn't. So, any problem with that manner of exam from this point forward anyway, for any endorsed experts? Okay. Do we want to keep going? Or do we want to recess? Let's,
We're not ready to go because we can talk before.
Okay.
Mr. Campbell, agree that you and I.
Okay. I'm sort of tongue in cheek. Yeah, I sort of thought we were going to stop at this point, and I'm grateful to be able to go do a little bit of research on a different case than this one, that I have to have a meeting with two of my colleagues on at 5. So I appreciate it. Terry, are you with us tomorrow? Oh, no. Oh, sadness. Okay. Okay. Well, we won't see Ms. Heacock tomorrow, but I expect we'll see her Thursday, and I look forward to my privilege of continuing to serve the parties in this case. Anything else we need to address before recess? All right, for our court security staff, thank you so much for taking care of us and keeping us safe. We're very grateful. Court's in recess. We'll see everybody tomorrow. 8:30 is the plan, I think. Okay, 8:30, great. Please go about your business. Thank you. Have a nice afternoon.